May I, Your Lordship?
Yes.
I beg to mention item number 5 on behalf of one NJ Das. As the learned counsel for petitioner is out station and therefore he could not make it to court today.
Which respondent? Which counsel?
Item number 5,
Yes. Who is not able to come?
NJ Das,
NJ Das.
the leading counsel.
Okay, let the matter be called. We'll pass necessary orders.
Your
Okay.
Lordship.
My lord, I'm praying for the adjournment of this matter for today. The conducting counsel, due to some personal difficulties, unable to appear.
Who? Petitioner?
Yes,
What difficulties?
My lord, I was intimated. In that case, my lord, can it be? What do you?
Mr. Sonar, who is not available today?
Yes.
Mr. Sonar?
yes, ma'am.
Sonar, what has happened?
He's facing some issues, domestic issues, my lord.
I see.
Yes, yes.
Then what about the reply affidavit? Will he be filing?
No, my lord.
Huh?
Affidavit, my lord.
Reply affidavit? Affidavit in reply or whatever,
No,
joined
It
affidavit,
is
whatever you
fixed
call
for
it.
hearing, my lord. It shall be fixed for hearing.
Hmm?
It was fixed for hearing, my lord.
No, it is for admission.
Admission, yes, admission hearing.
You have no instruction to that effect regarding filing of rejoinder. All right, when do you want it?
Yes. My lord, after vacation, my lord.
Which vacation?
This puja, ensuing puja vacation, my lord.
We don't have, there is no interim, so we don't have any problem.
Puja vacation is a bit far away. It's in October, isn't it? We are in August.
Yes, my lord.
Why do you want such a long?
Sir, my lord, he's the conducting counsel, he's challenging the constitutional validity, so he needs some more time.
Let's join it for 1 month. One
Yes,
month, not after vacation. Mr. R. Sonar, learned counsel for the petitioner, is reported to have some personal difficulties today. On a mention made on his behalf and not objected to by the other side, matter stands adjourned for 4 weeks. The petitioner may file rejoinder affidavit in the meantime, if so advised.
But in that case, may I pray for a date? My lord? That makes it convenient for me.
Yes, give a date, give a
25th.
date. 1 month.
25th of September. my lord.
Okay, list again after on 25th of September.
Obliged.
May I please, Lord?
Yes,
This retaping has come for the first time, manner for admission, and I don't have any interim payer as such. Otherwise, my lord, the issue is like this, my lord. The petitioners are claiming compensation as they are project affected persons for the Subansiri Lower Hydroelectric Project. Now, a board was constituted pursuant to a direction issued by this Honorable Court. Thereafter, a compensation was determined. Then, since the NHPC has to pay the compensation, the loss assessment report was sent to the NHPC. But NHPC returned the report saying indirectly it's a small order, 1-page order. On the ground, which they have tried to justify in the writ proceeding, that according to them, we are not, our village doesn't fall within the submergence area of the project. Now, our area is a area with the name of which is Dibe Village.
what village?
Dibe, D-I-B-E,
Deep.
Dibe Village.
Okay.
Now, the loss assessment report of 2008, which they do not disown, clearly mentions about the Dibe village. But their contention is that from our village, only 5 hectares of land will come within the submergence area. and rest will not come.
Hmm.
But for this, there is no document to support.
Hmm.
It is their submission only.
Hmm.
The loss assessment report, there are two loss assessment reports. One is of 2008, which they have complied, although initially with some objection. Now, there was subsequently on our representation when the authority refused to undertake a resurvey, we approached this honorable court. This honorable court directed that, yes, kindly do the re-exercise, resurvey. Pursuant to that, a resurvey was conducted.
Hmm.
Then in the resurvey, it was found that our village comes within the submergence area. Accordingly, a compensation was determined. Then it was sent to the NHPC. Now, NHPC did not participate in the proceeding despite repeated request by the deputy commissioner of that district, my lord, on the ground that according to them, whatever compensation they have already paid, they are not going to pay any further compensation. And so, my lord, I should not say the almost single judge this time
Hmm.
says that the direction issued by this honorable court earlier, single judge earlier, ought not to have been issued. That probably is not within the power of the single judge, my lord. Since this honorable court directed that there should be a fresh exercise, fresh exercise was undertaken, compensation was determined. Now, NHPC is saying, no, we did not participate because according to us, we are not inclined, required to pay.
No, there are already 2 rounds of litigation.
No, yes, this is second round.
This is second round.
In the first round, there was no, my lord, examination of the matter as such. This honorable court only directed that we kindly conduct a resurvey and find
No,
out.
no, regarding that observation you just mentioned that there should not have been a direction to resurvey. Resurvey direction was there as an interim order.
In this case, in the first round, I annexed that order.
Okay, in the first round, there was a resurvey.
In the first round, there was a direction to the district administration to do resurvey. When resurvey was done,
During the pendency of the
yes,
litigation.
no, that was disposed of.
Okay,
First round litigation was disposed of, directing resurvey.
okay.
Now, they are taking a plea that NHPC.
So that was the first case.
That was the first case.
Then the impugn order which is challenging today is the second case.
No, impugn order, yes,
Second case.
Second.
Of course, this is a read appeal now.
Yes, ma'am.
There are 2 cases.
Yes.
Right.
The first one is disposed of. In the second, the resurvey exercise that was undertaken,
Mhm.
NHPC did not participate. They were repeatedly asked, Deputy Commissioner says, we have issued notice after notice, they did not turn up and they didn't participate. Today they say, no, your area doesn't come within the Divi village. Now, interestingly, my lord, which area is covered, which area is not covered, there is no demarcation, admittedly. Even the loss assessment report of 2008, which they have accepted, pursuant to which they have paid compensation, mentions the name of Divi village. And there it is not indicated that only 5 hectares of Divi village is covered. Now they have made a submission that only 5 hectares of land is only covered from that village. But there is no document. There is nothing to support that, no material at all. Now the Honorable Single Judge says that the Honorable Single Judge is doubting accepting the submission of the NHPC about the credentials, about the conduct of the persons who have conducted the resurvey. And NHPC did not participate. Then in the writ petition, towards the end, we made a prayer that yes, if they have not participated, kindly direct them to do another exercise, fresh exercise, and directing them also to participate. That was also not accepted by the Honorable Judge. But at the end of the Lordship kindly see, on the one hand, the Honorable Single Judge says that I'm not accepting the report, despite the fact that there was a direction of this report, pursuant to which the resurvey was done. And on the other, the Honorable Single Judge says, no, if any fresh exercise is undertaken, it should be done by persons who have expertise in the field. So if the Honorable Court itself is saying that some resurvey is necessary, the writ petition ought not to have been rejected, dismissed, my lord.
This resurvey was not accepted by the Honorable Single Judge.
Yes.
What was the ground? What was the reason?
My lord, I'm
Because NHPC did not participate, that's why.
this is one of the reasons. The second is they have raised a plea that persons who have conducted the resurvey do not have the expertise. Deputy Commissioner being the collector, he is a person who should be involved. He has constituted a board of all high officials of the district administration. Lordship, may I kindly turn to page 110. Kiman tera? The last paragraph, madam.
Para 52. para 52
Yes, my lord.
of the judgment.
Yes. In the result, I find no merit in this petition and accordingly the same stand dismissed, leaving the parties to bear their own course. However, dismissal of this petition would not be a bar for the authorities to carry out a fresh exercise by persons having expertise in the field and taking all the stakeholders together. The authority may also consider taking recourse to modern scientific method such as remote sensing and satellite imaging analysis if any such venture is made in future. So if the Honorable Single Judge is
So what is wrong in that? They
No,
say that you let the expertise be there.
My lord,
If you want to survey.
we would have accepted it had it been a direction. It is now, liberty has been given. They will never participate. They have not participated earlier also. They are avoiding everything, my lord. My lord, I should not say, my lord, compensation has been paid to persons who are not entitled. And persons who are actually entitled, they are deprived. Now they cannot come in the open and say all these things.
Right, let the matter be examined. We'll issue notice as today. Who's for the other side?
But NHPC, we tried to serve notice. They said unless they get notice from the court, they have no right,
All right.
authority or
So
to appear.
let there be a formal notice.
My lord,
Who are the parties here?
state respondents and the NHPC.
What's the ID for 4 and 6?
One is, my lord, Union of India.
Issue notice.
One will be possibly represented by Union. No. Notice will go for 2 and 3, my lord. One is Union of India Standing Council is there for Shri. One is represented by my learned friend there, my lord. And then 4, 5, 6, 7 by my learned friend, Mr. A.T. my lord.
Please write, heard Mr. D. Mazumdar, Learned Senior Counsel, assisted by Mr.
S.K. Devi,
S.K. Deori
my
for the appellant. Stop by filing this writ appeal. The appellant has challenged the judgment and order dated 7/8/2023, passed by the learned single judge in WPC number 674 AP of 2017, whereby the writ petition was dismissed. To stop, the learned single judge has, however, observed that the authority concerned is at liberty to take recourse to carry out fresh exercise by persons having expertise in the field and taking all the stakeholders together. To stop, the learned senior counsel submits that despite several intimation and notices issued to the NHPC
by the deputy commissioner.
by the deputy commissioner, they have failed to participate in the
Resurvey exercise,
resurvey exercise
which was conducted pursuant to the action issued by the Supreme Court
conducted pursuant to the direction of the learned single judge
in WPC number 299 AP of 2013.
in WPC number 299 AP of
2013.
2013.
Yes.
Full stop. Therefore, it is unlikely that such exercise will be, even if such exercise is undertaken, the NHPC would not participate in the process. Stop. As such, the learned senior counsel submits that the impugned judgment and order should be interfered with. Next para. Next para, considering the above submission, we are inclined to examine the appeal. To stop. As such, let notice be issued to the respondents, returnable by 4 weeks. Mr. D. Kamrup, Learned State Council appears for respondent number
5 laws.
5.
Yes.
Then
I'm for 4 and
Ms.
6.
Ete appears for
4 and 6.
respondent number 4 and 6.
I'm referring on behalf of M. For respondent number 1.
And your name?
M.
Your name,
And Sora.
Mr. N. Sora, appears on behalf of Mr. M. Kato, who represents respondent number 1. Stop. Petitioner appellant,
Let's say on the 7, so he is. Yes. 7 is.
Yes.
For 7 also she will appear.
Ms. Ete, also for 7.
Right.
Then petitioner appellant to take steps for service of notice upon the remaining respondents by registered post with ADD within 3 days.
We'll
Let's
take by
go back.
dust him. We'll take.
Additionally, or
Yeah. Let it be dusted itself
Okay.
will serve in the office.
petitioner to take steps for service of notice upon the remaining respondents by way of Dusty. Stop.
True.
However, an affidavit indicating notice be filed. Dusty notice be effected within a period of 10 days. List the matter again after a month for admission.
My lord may admit it, my lord. The matter will be heard now. It's a.
No, let notice go first. And let NHPC come, we'll see.
Matter.
Yes.
My lord, lordship may possibly clarify that Dusty in respect of respondent number 2 and 3. The NHPC 2 and 3.
Okay, Dusty in respect of the remaining respondents, that is respondent numbers 2 and 3.
Obliged.
Yes. Parties have received the judicial inquiry report as per the last court's order.
Yes, my lord, we have received the
All right.
judicial order.
Okay,
Allow me 3 weeks time may be given to file affidavit.
affidavit against what?
My lord, for this instruction given by the Indian Army. We have received the instruction judicial.
You are for which party?
I am for respondent number 3, 6 and 8. Union of
6 and
India. Union of India, on
Okay.
behalf of M. Kato.
You want to file counter affidavit
Yes, ma'am.
against the inquiry report?
Yes. No. Yes, my lord. Yeah, ma- 1, 3.
Judicial inquiry report. ये तो मिला नहीं हम लोगों को।
You have received the, what do you call the judicial inquiry report? Isn't it?
Yes, ma'am.
All right, as paid for by the learned counsel, Mr.
And Sora.
N. Sora, appearing on behalf of Mr. M. Kato,
Yes, ma'am.
learned DSG, who represents respondent numbers
1, 3, 6 and 8.
1, 3, 6 and 8.
Yes, ma'am.
3 weeks' time is granted for filing counter affidavit. List again after 3 weeks.
Give the pledge.
Yes.
Lordship notice has issued lordship.
Ah.
But no any ID card till.
Okay.
As per office note, ID card regarding in respect of R2 not received. R2 is informant. This is a 302 case.
So in the meantime, can we direct for preparation of paper book? Will I-
Yes, LCR we received already.
All right. Parties are represented by the respective councils, except for respondent number 2. Gustav office notes indicates that AD card has not returned back from respondent number 2. Gustav, as such, that the matter be adjourned for 2 weeks, awaiting service report from respondent number 2. Gustav, next para, it is further seen that the LCR has been received. Gustav office to prepare the paper book and list the matter again. office to prepare the paper book in the meantime. No, office to prepare paper book. That'll do. List again after 2 weeks.
Obliged.
Much obliged.
You're for the state.
I'm for the state, Your Lordship.
Then somebody has appeared for respondent number 2.
Yes.
Please write out. A mention has been made on behalf of Mr. I.N.J. Das, learned counsel for the appellant, to the effect that he has some personal difficulties to appear before this court today. And therefore, the matter may be adjourned. Stop. Miss, your good name? Your good name, please?
T. Ginny, Your Lordship.
Ms. T. Ginny, learned additional PB, is present and submits that the LCR has arrived, and therefore paper book may be prepared. To stop next para, in view of above, office to prepare the paper book and list the matter again for orders once the same is ready, and copy served to the parties concerned.
Diplo.
May please, Your Lordship. Last occasion, Lordship, the counsel for the respondent number 5 is taking time to file a reply regarding the IA 47.
Okay.
IA 47 is here applicants is seeking permission from this Lordship to file a writ appeal because he was not made a necessary party in the single page. Lordship. This is the IA 47.
IA is for leave to file a third party
Yes,
appeal.
yes.
Okay. Why do you want to file appeal? How are you affected?
Because I am adversely affected here.
How-
Because
how?
of Lordship here, there is an interview for assistant professor.
Yes.
And here, what happened, there are actually, there are 3 posts for the PWs,
Hmm.
person with disability.
Okay.
And the APCS has given, during declaration of result, what happened? The APCS said that this is quota for the ST only, not the for the general. But later on came to know that one of the, who is the writ petitioner, he has filed the writ petition. Then during hearing, came to know that one of the posts is reserved for the general quota.
What?
Reserved for the general quota.
For general.
For here. Then the learned single judge has directed that the writ petitioner should be appointed, giving all consequence benefit. And later on, this present applicant came to know that as per the merit, interview merit list, he is above than the writ petitioner also.
I see. And both of you are from the general. Both
Yes,
of you are from general.
Yes, I am from general.
Writ petitioner also from
Oh,
general.
from general also.
So
Here are another one more candidate is there who is above the writ petitioner also.
okay.
They have either none of them made as a necessary party in the writ petition also.
So how many candidates are above the writ petitioner?
Yeah, two, including me, two.
Two.
I am the highest mark obtained in the interview. Then
Okay.
next to me, one is there. Then
And the
third
writ
number
petitioner
is,
third.
yes.
I see.
This is the case, Lordship.
So
And this
direction
IA is,
of, direction of the learned single judge was to appoint the writ petitioner
yes, Lordship.
in the general category.
Yes, Lordship.
Yes, respondent number 5 is represented by anyone? Mr. Apang is for the APSC.
APCS, Lordship.
You have any objection to the application?
No, I have no objection.
Okay. Then what about respondent number 5? Anyone appeared?
Yes, last occasion he has
Time was
appeared and
granted.
he taken time for filing a reply.
What do you do, brother? Your good name, please.
M. Bath, Lordship.
M?
M. Bath. M. Bath.
Mr. M. Bhatt, learned counsel, appears for the applicant. And submits that by filing this application, the applicant seeks permission of this court to file a third-party appeal against the judgment dated 6/5/2022, passed by the learned single judge in WPC number 291 of 2019. Most of the learned counsel submits that the applicant is affected by the direction passed by the learned single judge, but he was not made a party in the writ proceedings. As such, he submits that the applicant may be permitted to file a third-party appeal. Mr. A. Apang, is it? Learned Senior Counsel and Standing Counsel, AAPSC, submits that he has no objection to the application. It is further seen that although the respondent number 5, who was represented by Mr. Ahmed, was given an opportunity to file objection to the application, but objection has not been filed till date. Moreover, the respondent number 5 is also not represented today. Next para, be that as it may, having regard to the statements made in the application, we deem it proper that the application should be allowed in view of the fact that the applicant appears to be affected by the impugned judgment and order as referred to here and above, while he was not made a party to the writ proceedings. Stop. The application for filing a third-party appeal is therefore allowed. IA stands disposed of. Now we come to the next IA.
Yes.
This is for condonation.
Yes, condonation notice. The notice can be issued.
All right.
Yes, Lord.
Heard Mr.
M. Bhatt.
M. Bhatt, learned counsel for the applicant, who submits that by filing this application, the applicant seeks condonation of how many days?
228 days.
Sorry?
228 days. Lord.
No, you have corrected that already. It's 201
Oh, yes.
in our copy.
Okay.
201 days delay in filing the connected writ appeal against the judgment and order dated 22/7/2022, passed by the learned single judge in WPC number 291 of 2019. We'll stop next para. Issue notice to the respondents returnable by 3 weeks. Mr. A. Apang, learned standing counsel, AAPSC, appears and accepts notice on behalf of the respondent number 3. And Mr. I. Ram, learned counsel. Learned- You're standing counsel or government advocate?
Government.
You are
Government.
learned government advocate, accepts
Commissioner
notice on
government.
behalf of respondent number 2. Then what about others?
Others are Lordship, the education department, that is, standing council is there, but today I think Jammo, Mr. Jammo, yes, no. Anyway, I will take a steps.
Four you cannot accept, isn't it, Mr. Appa?
No.
Four is by name.
Yes, by name.
Applicant to serve notice to the respondent number one through Mr. T. Jamo, Learned Standing Council, Education Department. And thereafter file the acknowledgement received from him before the registry. Stop. Applicant to take steps for service of notice upon the respondent numbers 4 and 5 by registered post with AD due within 3 days. List the matter again after 3 weeks. Respondents are at liberty to file objection to the IA if so advised.
Okay.
Your lordship.
Yes.
For lordship's convenience, this is the list of days, lordship.
This is a writ appeal.
Yes,
You are the writ petitioner or the respondent?
respondent.
Private respondent.
Respondent in, yes, private respondent in the writ petition.
Private respondent.
The issue is, lordship, the writ petitioner had filed the petition alleging that there were some irregularities and that she had secured more marks than me, basing on some RTI information. So therefore, my appointment was set aside and direction was issued to consider her appointment. Now, lordship, so many things have happened in the meantime, lordship. There is a post of lower division clerk, and the recruitment rules are at page 51 to 53. The date of the notification is 17/3/2008. Lordship may refer to later on, just for the sake of
No,
understanding.
we are concerned with what post?
LDC,
LDC.
yes. Lower
So-
division clerk,
Okay, there was a selection done by the
district administration.
district administration. How many posts are there? Against
At that time advertisement, there was only one post.
one post.
Of course, we have submitted a document in 2017, which is, lordship, which shows that there ought to be 8 posts. And there was a direction from this honorable court also that I may be considered if such other posts are advertised. But there is another matter, of course.
Another
lordship.
matter. Otherwise, it was only one post.
Yes, the advertised.
You
post
were
was not-
appointed,
I was appointed.
but your appointment has been set aside.
Yes.
On what ground?
The petitioner had filed RTI information. According to the petitioner, initially what happened is after the written exam was held and the result notification was held, page lordship, page 33, lordship.
No, before we open the pages.
Yes,
just
yes,
tell me-
Lordship.
Tell us generally,
Yes,
um,
her claim was, lordship, as per the initial result notification, the mark secured by me was 235,
yes.
and the mark secured by her was 232.
Hmm.
The written exam result secured by marks secured by her was 214 plus the viva, that is 18.46.
Hmm.
So that comes into 232.46. Then in my case, the written exam result was 204 plus 33.76. That is marks of the viva.
Hmm.
So that comes to 235.76. Now, lordship, they had, in the meantime, according to them, they had filed this RTI application. Initially, they had filed the RTI application on 7 February 2017.
Hmm.
According to this RTI application, they had asked for the answer sheets but that was not given, saying that those papers are not with the PIO at the moment because the recruiting agency had not sent it yet. There was a reply given to them. That was in 2017. Then in 2018, after more than a year, that is on September 2017, they filed second RTI application. And in that second RTI application, the mark sheets were given, the mark sheets of the petitioner lordship. So according to that mark sheet, her written exam result marks were not 214, but 282, lordship.
282.
282, such a high jump in marks. For maths, general English and GK, it was 98, 88, and 96 respectively. So that was placed before this honorable court. I mean, that was part of the writ petition. The interview, everything was held in 2016. 2016 itself, I was appointed in month of December as per the result notification. 2017, the first time they filed RTI, it was not up to their satisfaction. Then in 2018, as per their own statement, they had waited for the previous DC to go on transfer. After that, previous DC had left, after more than a year, they had filed another RT application asking for the answer sheets. And as per this answer sheets, her marks were 282 instead of 214. So, and there was, and in the RT application, they had also seen some Viva mark sheets and Viva evaluation sheets. Then a tabulation of marks in which only the petitioner's marks had changed. My marks and other marks remained the same in the tabulation, which they have, which they received through RTI in 2018. Thereafter, they filed a writ petition. And in the writ petition, interestingly, your lordship will see that the respondent, because I am not, lordship, I am not custodian of this, this paper. So I have really nothing to say because so far as I'm concerned, I have applied for the post. I have tried my best. I have been successful, declared successful, and I was appointed. But the main person who was to answer these questions was the government. The government affidavit, your lordship will see there is nothing, absolutely nothing on record. Everything is no comments, and no comments, lordship. So that is how this honorable court came to pass the impugn order, saying that government has not been able to show as to why the writ petitioner should not be replaced, should not replace me, lordship. So that is why my appointment was quashed. So that is why I'm before your lordship. Now, lordship, as per lordship order of this honorable court, after filing this writ petition, we had come to some information through RTI, which we have filed. And this honorable court has, in fact, when the writ appeal was heard for the first time on 6/6/2022, this honorable court has directed the government to produce the records of the recruitment process. That is on 6/6/2022. Then on 25/7/2022, the records were not produced. So we had also asked this honorable court, we had prayed this honorable court that we have received certain information from RTI, so we may be allowed to file additional affidavit. This court had allowed the same by order dated 25/7/2022. Then lordship on by order dated 11/8/2022, the writ petitioner respondent was also allowed to file counter affidavit because we have raised new grounds by the additional affidavit file, which has not been filed, which was never filed till date. That is, it's been more than a year now. Now, so we'll have to say that they have admitted whatever is filed in the additional affidavit, lordship. Now, lordship, in the additional affidavit, very interesting, lordship. We had, according to them, lordship, they had filed the RT application asking for the answer sheets. And the answer sheet shows that they secured 282 marks instead of 214. So we also filed RTI application asking the respondents to give us all the answer sheets of all the candidates to satisfy ourselves also, because if there is something wrong, we ought to know. So we filed this RTI application. When we filed the RTI application, the respondents, we asked all the papers. In fact, we asked the file notings also of the recruitment process. The respondent in the reply to the RTI has said that they conducted a board, they constituted a board for opening the locker in which all the documents are supposed to be there. So on the basis of that committee, they opened the locker and videographing was also done. Interestingly, what was found that the original answer sheets of the petitioner was missing, but the answer sheets of all the other candidates, including myself, were there. So we don't know from where the RTI, they got this RTI. The original answer sheets which ought to be there in the locker, it was not there. So as also the recruitment, the file by which, in which the recruitment process was recorded, that was also not there. The only thing they found was only a computer, when they did computer typing test, the computer typing test marks, the tabulation of work marks was also not there. Only the physical marks which was on the computer type papers, they were there, that was given to us. So Lordship, had the record been called at that time when the writ petition was filed, if that veracity of that RTI application, whatever was there, if it was found, and this court would certainly not have passed this kind of order. Also, Lordship, I'd like to mention one thing. The records will be produced by the government. I have seen the RTI application, which was, RTI records that have been given to us. In the answer sheets, it is objective type answers. The answer, it is not a descriptive, objective type. So in the instructions given, they are supposed to circle the answers. The candidates are supposed to circle the answers. In the answer sheets which have been filed in the writ petition, which they allegedly received from the RTI applications, so far as mathematics mark sheet is concerned, that is okay. Answer sheet is concerned, that is okay. So far as English, general English and general GK is concerned, it is not circled. All the answers are tick mark. Unlike the rest of the candidates, none of us had ever tick mark. We have already followed the instructions. So I don't know if this is the right thing to do, because when the tick mark is there, suppose that there are 4 options, A, B, C, D, then suppose in the A portion, 1 tick mark is there. Then there is another tick mark to show that that answer is right or wrong. In our case, when the circle is there and a tick mark is there, so the tick mark is done obviously by the evaluator. So it is possible to know that that the answer was right or wrong. But in this case, in some places there are tick marks in option A and option B as well. So it's difficult to know whether it's that of the evaluators or the candidates. So Lordship, everything in my humble submission will boil down to the government's stand, Lordship, government's records, Lordship. This, in my humble submission, this is not what it seems, Lordship. It is also very interesting to note that the petitioner, after filing RTI way back in 2017, when it was not to her favor, she waited 1 whole year and thereafter filed the RTI application. So, Lordship, my humble prayer is that this writ appeal, of course, I'm aware that the other party will say that we have brought new materials on record, Lordship, but this is something we came to know after the writ appeal was filed, Lordship. And
See, Ms. Duncan.
yes,
In the first 2 orders,
yes,
there was a direction to produce the records.
yes.
So was it produced at any point of time?
No, it was not produced. Today, if they have, they may produce.
Who's to produce? The government.
Government, Lordship.
This pertaining to which department?
This is district administration only,
District administration,
Siang district.
not a particular department.
No, in the DC district administration, it is sort of
Under the office.
under the office of the district administration,
Siang.
Siang.
Siang district.
Siang district.
So who's appearing for the? Mr. Tapin, you're there?
Yes.
Do you have the records with you?
Yes.
Show, where's the records? Just that. What does it contain?
Lordship, the answer sheets of the Lordship, for the petitioners and the read petitioner and the private respondent.
Okay,
And so far the Lordship, answer sheets of the private respondent is concerned Lordship. The original is not there Lordship. Original is not there Lordship,
it's not there. Why?
but the photocopy is there Lordship.
Why?
As per the instruction that I have received Lordship, it is not found here Lordship, the original.
Record should contain not only the results and answer sheets of the petitioner and the respondents. The record should contain the result sheets and the answer, the mark given to all the candidates who participated in the selection process. This is no manner of maintaining the record.
So far results of others are concerned Lordship. That is also, but their answer sheets are not there. Oh, yes, that's
That
correct.
should be
Lordship, but
there.
Since,
Beginning with the advertisement, culminating into the result notification. Each and every record should be there in original. Otherwise, you have tampered with the record.
What is this record? This is only in respect of the petitioner and the private respondent.
private, so far answer sheets are concerned.
Answer sheets are concerned. Why have you segregated it?
Because, Lordship, it's relevant, therefore, Lordship, I think they might have.
Huh? No, how can you
I will
segregate
also
it?
submit my note at one
Only,
point.
only two persons are
How takes
participating.
it stand on its head. As if I am a beneficiary of something.
No, see, thing is that, see, when we ask for the records,
No, what I'm saying, I will submit my note.
when we ask for the records, why should it be just the records of two individuals? As if they are the only two persons who participated in the proceeding.
In that case, Lordship, I may ask for again those records.
Because there's a note sheet also. Note sheet will indicate.
All records should come in study from
Note sheet
the
is there.
advertisement.
Huh?
Not-
Yes, yes, Lordship.
The
All
note sheet
records
would
should come.
speak about the entire thing, isn't it? There'll not be a note sheet prepared specifically for
No.
the petitioner or for the
Note sheet
respondent.
is about the whole, sir, Lordship.
Exactly. So that is why I think in order to appreciate the thing, when we ask for the records, it should be the entire records.
Also, Lordship, when they bring the records, Lordship, I have a prayer, Lordship. As per the RTI information which we have received, that is the physical marks on the computer test, it appears that the words that have been typed, all the candidates have typed more than 100 words. Now, as per the recruitment rules, they're supposed to have a qualifying words of, so to say, 33 words per minute. So my instructions are that the typing was done for 5 minutes and not for 1 minute. And it is quite plausible because nobody, I think everybody here knows that it will be impossible to type more than 100 words in 1 minute. So that instruction may also be sought, Lordship. How many minutes that typing test was held, Lordship? Because then we'll be able to calculate whether
What
that-
was this, in what manner the selection was held? And one is,
First
one
written
is
test.
typing test and before
written
that,
test, Viva, and computer typing.
written test, computer, written test, Viva, then
Computer
computer typing.
typing.
Okay. Now this records which you have produced today is pertaining to which one, Mr. Tapin?
This is written
Written and
Lordship by one.
Viva.
Viva.
What about typing test?
Typing to his Lordship is not properly reflected here. Lordship.
It should be
The
reflected.
marks which have been given. to-
Supposing a person who does not know typing at all, can he be selected?
Yeah, Lordship, that-
Because LDC, I think the post of LDC requires
Yes,
typing.
Lordship.
I have perused.
Earlier it was typewriter, now it's computer knowledge.
Correct.
They have to type on the
I
computer.
have perused the records, Lordship. It reflects Lordship, so the result is concerned.
If Lordship come to the page 64, result loss.
Hmm.
This is the final result shown in the Lordship, this particular result declarations order Lordship. There Lordship, the written test, written marks of the petitioner and viva is given there. And in respect of the private respondent also, in respect of all the candidates Lordship, only the written and viva tutors have been given. Lordship.
No, Lordship, I think
While
there is a
page
mistake
64
here.
is the Lordship, page 64 Lordship. It's a result Lordship.
Anyway, you produce the
Not
entire
the
records,
result.
we then will examine.
It's a
All right.
statement given by the PIO then. So it's a wrong statement, wrong information.
So that's why we've asked for the records. We'll see for ourselves what the records say.
But
All right.
what I find from how this appeal has been filed, of course, I will argue when the matter is taken up. It is, I was not a custodian of that. I was furnished the documents by the public information officer. If something has
You are
happened
appearing for,
later on,
Mr. Pangi, you are appearing for which party?
I was a writ petitioner therein.
Oh, you are for the petitioner.
Yes.
Okay. Anyway, we'll hear you at the relevant time. As of now, we'll
Yes.
ask for the records.
Lordship, I may like to repeat what I stated earlier, Lordship, that instruction may also be sought as to how many minutes that,
I've heard you,
yes,
Ms. Tanvi.
Well,
Need
I'm-
not repeat.
I'm
Yes.
objecting to that on a simple ground. These were not grounds before the writ petition.
Anyway. We'll see.
but the records were not seen at that point of time. And it is compulsory that they have to type 33 minutes per 33 words per minute. And that is one of the qualifying grounds, Lordship. In my humble submission, it appears that she has typed only 18 words per minute
All right,
as per
please write down. The parties are represented by the respective councils. The records produced by Mr. S. Tapin, learned senior government advocate, appears to be incomplete. To stop. The controversy raised by the writ appellant, who was the private respondent in the writ proceeding, is that there has been tampering with the marks allotted to the candidates concerned in the selection held for the post of LDC. Stop. The selection comprised of written test, viva voicing and computer typing test. Stop. In order to appreciate the manner in which the candidate concerned was selected for the post, Mr. S. Tapin shall produce the entire records pertaining to the selection. What is the reference there? Selection held on?
Selection in terms of advertisement dated 25/8.
Selection held in terms of advertisement dated 25/8,
2016.
2016
Yes.
in the establishment of Deputy Commissioner, Siang District,
Siang District.
to enable the learned senior government advocate produce. No, cancel that. List this matter again. When?
Almost 2 weeks maybe.
2 weeks. We have a date?
After 2 weeks, any date was.
Because you need to produce, that's why it'll be easier for you if we have a date, otherwise there'll be uncertainty.
September.
All right, 11 September 2023.
Obla.
Obliged.
Take back this record.
Close.
Lordship, may I?
Yes.
Lordship, in regard to the item number 9, the leading counsel is out of station. Some more time may be given for this matter fixed in this month of 24.
Who is the leading counsel?
DAJ, Mr. M. Kator. He's out of
24
station.
means
He was here last Friday. Where is he?
So he's out of station. He's in Aloha for some urgent domestic problem.
Yes. When? So when do you want it?
24 of this month.
Can it be Lordship on 23? Because I had a talk with him. He's supposed to come back tomorrow.
Twen- 23. You mean the after tomorrow? Wednesday?
Wednesday.
What is the issue involved here? Compensation?
Yes.
Yes, company.
Huh?
What happened, my lord? 4 parcels of land were, my lord, acquired for
Yes.
the ITPP, my lord.
Hmm.
Then award were passed, my lord. For the non-payment of the award, the landowners approached this honorable court by filing 2 writ petitions, my lord.
Hmm.
In the writ petition, my lord, the learned single judge had directed, my lord, to make the payment, my lord. Then against this, my lord, after 2 years, they filed writ appeal, my lord, against the single bench order, my lord. Writ appeals were dismissed, my lord.
Hmm.
And thereafter, my lord, they filed, the ITP filed, instead of appealing before the Supreme Court, they filed land acquisition appeal before this honorable court, my lord. That was also dismissed, my lord.
After the dismissal of the writ petition,
Writ appeal, my lord.
writ appeal,
Yes, my lord.
how can it be?
Yeah, that's why, my lord. Therefore, on dismissal of that writ appeal, LA appeal, my lord,
Huh?
they again filed writ petition, 2 writ petitions before this honorable court, my lord.
Challenging what?
Challenging, my lord, the award and the notification, my lord.
No, how can it be? How can it go on
Yes,
and on
sir.
like that?
Yes, madam. The writ petition, there are 2 writ petitions, the new writ petitions, they filed by the ITP were dismissed, my lord.
Ah,
On the ground there, my lord, there is a res judicata, my lord.
okay,
Because, and my lord, there are lessons, my lord,
okay.
on the part of ITP in filing the writ petitions, my lord. Then those writ petitions were also dismissed, my lord. Then again, against the dismissal of these 2 writ petitions, they filed this present appeal, my lord. And my lord, in the meantime, my lord, they have also filed, and my lord, there was a contempt pending, my lord, before this honorable court, my lord, in single, my lord. They have filed, and my lord, SLP before the Supreme Court, my lord. That was, in the SLP, there was a direction to the ITPP to deposit the entire, my lord, compensation amount before the deputy commissioner. And accordingly, my lord, the ITPP has also deposited the, my lord, amount before the deputy commissioner. And when ultimately, my lord, the SLPs were dismissed, my lord, by the Supreme Court, my lord. Thereafter, these 2 writ petitions were filed before this honorable court.
Challenging what?
Challenging, my lord, those, my lord, award and the notification, my lord.
Again?
Again, my lord.
Why are you going again and again, coming again and again?
Lordship, some more time may be given so that I can come with a clear instruction. Otherwise,
Huh?
24 of this month, matter may fixed.
Why not Wednesday?
He may be back here at
Huh?
24.
In fact, morning he called me up, Lordship. So I said, let it be on Wednesday. So that is 23rd.
List on Wednesday, as paid for on behalf of Mr. M. Katol and ASG. DSG. We'll see. Let him come on Wednesday. If he's back.
Lordship.
Hello.
May I please, Your Lordship?
Yes.
Lordship, item number 25 may be taken on Thursday because despite our best report, the file, we have to make another file.
Item
25, Lordship.
you're for the state.
State respondent. Lordship.
Who's for the petitioner?
I'm for the petition.
Are you filing any rejoinder?
No, my lord, we have filed an additional affidavit, my lord, bringing all the materials on record, my lord.
You will not file rejoinder.
No, my lord.
Okay.
I have received the affidavit today.
What is that?
Affidavit, additional affidavit filed by the petitioner.
Additional affidavit.
My additional affidavit only annexing, my lord, the awards, my lord, passed in, my lord, different projects, my lord.
So we have received.
Here, my lord, the matter pertains to, my lord, the land was acquired, my lord, under, my lord, 19 Land Acquisition Act, my lord. Where, my lord, and my lord, solutions were given, my lord, 30% solutions were given, my lord. Our claim is that, my lord, by the lapsing provision of section 24 of the new Lara Act, my lord, the new act is applicable, my lord. And in the new act, my lord, we have to get 100% solution. That is the only issue, my lord. And the state has filed the affidavit, my lord, the collector has filed the affidavit, my lord, and admitting the facts, my lord.
And you have filed additional affidavit
My lord.
incorporating what?
Incorporating, my lord, there is a, my lord, project, my lord, for construction of dam, my lord. For that purpose, my lord, 4 acquisitions were made, my lord. And in all the 4 acquisitions, 100% solutions were given, my lord. Only in respect of my case, my lord, 30% were given, my lord. That's the only issue.
Solution, 100% solution was given
Given to
as per the 2013 Act.
13 Act, my
So
lord.
just to show that we have filed that.
Yes, yes, my
I
lord.
see. Yes. You are for which party? Sorry, NHPC.
Yes, for that lordship, Mr. Tiwari is to be here.
Ah.
Representing the NSPC. So he's requested some time because he has to go through the affidavit also.
So when do you want it?
He is coming on 5th of September. Already is.
Mr. Saikia?
My lord, let it be on Thursday, my lord, because the NSPC has already filed the affidavit also. In the affidavit, they say that, my lord, it is up to the collector to determine that to go into that area, my lord.
No, let us have it on 5th of September.
My lord.
Let the party be there. As paid for by Mr.
K. Saxena
A. Saxena, Learned Counsel,
for the NSPC.
and it pay for the NHPC. List the matter on 5th of September 2023.
Wait, wait.
Yes,
Well, back to mention item number 5.
yes.
So, my lord, inadvertently, my lord, we missed filing 1 page, my lord, in your lordship's copy. My lord, I may be given liberty to withdraw it and file afresh.
Item 5
Yes, 1 page, my lord, we mistakenly did
All right.
not file.
on the prayer, Mr. Deep again. The writ petition stands dismissed as withdrawn with liberty to file afresh.
Yeah.
Yes.
All right.
May I please, my lord?
Yes.
My lord, I beg to mention item number 33
33.
on behalf of M. Khatam, my lord.
Yes. What do you want?
My lord, matter may be adjourned for the day.
For the day.
Yes, my lord, and consent from the petitioner also, my lord.
As paid for on behalf of Mr. M. Kato, Learned DSGI, who is reported to have some personal difficulties today. Matter stands adjourned for the day.
One humble submission, Your Lordship. Current matter may be fixed on 7 September and without any further adjournments, Your Lordship. 2017 matter.
You continue, huh? Continue, no full stop. To be listed again on 7th September 2023. As paid for. No further adjournment will be granted. Yes.
Leave the blessing.
Yes. What was this matter?
Also, instruction was sought and I have brought the instruction.
What does it say?
Lordship, so far the it has been resealed already, Lordship, building has been. Last page, Lordship,
Sorry,
last page, Lordship.
last page.
Yes. Yes. Second last para, Lordship.
Desealing.
Yeah, it was sealed and it has been resealed now.
Oh, so
Sealing has been opened.
so your repetition is structures.
Yes.
May I have
Lordship, the shops were open also, I have seen.
So we dispose of the writ petition as it appears.
Yes, Lordship. Lordship, expert,
Mr. Prema?
expert's recommendation is also there. Other
Hmm.
things. Expert recommendation is also there.
Page,
Lordship. This is annexure 1 is town planning, Lordship.
it's all right. I think we'll just take this into consideration,
Yes, Lordship.
the order of desealing. And on that note, we close this matter.
My lord.
Yes, Lord.
Next, please write down. In terms of the order dated 14/8/2023. Ms. G. Ete, learned additional senior government advocate, has obtained instructions, which is to the effect that an order dated 17/8/2023 was passed by the Deputy Commissioner, Capital Itanagar, the Extra Assistant Commissioner Itanagar, an officer in charge, Police Station Itanagar, shall conduct an exercise of de-sealing, dash sealing, SEAL, sealing of the building of the petitioner with immediate effect. We'll stop. The building, the owner of the building, that is the petitioner, has however been cautioned to take adequate measures while carrying out the construction of the upper floor of the building. So as to incident in future. Stop. Next para. Mr. L. Perme, learned counsel for the petitioner, submits that in view of the order dated 17/8/2023, the petitioner would not like to press the writ petition. So, next para. Petition stands dismissed, disposed of as not pressed. Or writ closed.
Applies.
The produced by the learned additional senior government advocate T23 is retained in the ratification. You have a spec copy of it.
Okay.
Sorry, item number 2, 3, and 4, my lord. It has been filed defective, my lord.
Okay. On the Utpatti's gra- Yes.
In 04/2023, the government of Arunachal Pradesh through Department of PHE and West Siang (17).
17.
Yes, page 16, 17,
No.
number 17,
Serial number?
17.
What is the name?
PWS at Patuk ADC HQ.
Okay. So we are concerned with this.
Yes, Your Lordship.
Hmm.
Your
What is this?
Lordship.
What is this? It's a road construction. Or what?
No, Your Lordship.
What do you mean by PW?
lakhs.
Then class of contractor who can undertake this work is class 3 and class 2. Correct?
Class
You-
3, yes.
You are what contractor?
2,
You are class 2.
yes, Your Lordship.
Okay, you have been selected by which order, by which document?
By 18/04/2023, Your Lordship, come to pay.
It's a comparative statement.
Pretty state.
Hmm.
In this order, I was selected, Your Lordship.
Petitioner is what? Harang Enterprise.
Yes, Your Lordship.
Out of 2 bidders, there were only 2 bidders.
Yes, Your Lordship.
MS Harang Enterprise under so and so. Parsi Parli Block has quoted the lowest rate. 4.99% below tender amount is recommended herewith for approval, please. This is sent by whom?
Executive engineer.
Executive engineer.
Yes.
Uh,
The chairman.
Chairman. What happened thereafter?
Thereafter, Your Lordship, SE Superintending Engineer actually cancelled the tender bid.
This minutes.
Yes,
Minus.
yes, Your Lordship. Yes, Your Lordship. complaint by orally and by writtenly, but they didn't accept my complaint, Your Lordship.
Where is your complaint?
Your Lordship, they didn't accept my complaint, so I did it annex it here.
Then how do we know you have filed complaint?
Yes, 18 July,
18 July or 10 July?
10, Your Lordship.
Ah,
25, page 25, Your Lordship.
yes, let us go to the typed copy, page 26.
Yes, Lord.
This is retendering.
Yes, Your Lord.
Then did you participate?
Yes, I participated in.
And what has happened?
Your Lordship,
Mr. Counsel, why do I have to ask you every line? What have you done? What?
Your Lordship, during this participation,
Ah,
there were many lacunae on the GT enterprise who was awarded on this particular day during this tender process.
there was what?
There was many lacunae in his application,
In the application of whom?
GT enterprise,
Who is GT Enterprise?
the
Petitioner?
no, Your Lordship, respondent number 5.
Okay, respondent number 5.
Yes,
There was some lacuna there.
yes, Your Lordship.
Then
Then I made that complaint to the SC, Your Lordship. But the SC didn't reply my complaint, Your Lordship.
where is your complaint?
Complaint is on last page, Your Lordship. Page number,
So based on the second tender,
yes,
this GT Enterprise has been selected,
yes,
selected.
yes,
But you have submitted complaint now
yes,
that there was something wrong with the
Yes.
tender.
with the applicant.
What
the
was wrong
applicant.
with the tender?
There were errors, Your Lordship. There were errors in decimal and in rupees or paisa were absent after the entry of figures.
When was the tender opened, the second one?
On 18/07/2023.
And tender was awarded when?
Tender
Contract
was
was awarded
on the same date.
same day.
Yes,
Do you have a copy of that?
no, Your Lordship.
No, it seems that there are there are no sufficient documents in your writ petition.
Your Lordship, come to Annexure 7, page 27. This is the forwarding approval financial bid by the SC to executive engineer.
Page.
Page 27. May I, Lordship, may I read?
Just a minute. 27.
27.
Yes, read.
To the executive engineer PIT WS Coloriang, Lordship, I was rejected on the same ground as I have mentioned in the applicant, in the petition. There was lacuna in my application too,
When was it rejected?
on the same date.
No, on the opening of the financial bid.
Yes, financial bid.
Before that, there was a technical bid.
Yes. Your
Was there a technical bid?
Yes,
You qualified for technical bid,
yes, your lordship.
only in financial bid.
Yes.
On what ground have you been rejected? Is there any comparative statement? Then how do you build up your case? Why are you saying that there are many anomalies and what do you mean lacuna?
Your lordship, during the Your lordship, why?
See,
Sorry,
Mr.
Your
Council,
Lordship,
Mr. Council, see. Just merely saying that there was lacuna in his bid will not do.
Yes, sir.
You have to show that your bid was in order.
Yes,
Everything is correct in order. Even in fact, I'm the lowest or maybe the second lowest, whatever.
yes,
I'm qualified. I'm entitled to this.
yes, sir.
Not just complain what was given to the other.
Yes, your lordship.
If you complain about him, okay, fine. But you also have to say that you are qualified. Your bid has been wrongfully rejected, despite you having qualified in all respect.
Yes, sir.
Then only court will examine. Otherwise, something wrong done to that person, why should we examine?
Your lordship,
You should claim that you are the one who's qualified and you should be the one to be awarded the,
yes,
correct?
yes,
But if you yourself are not qualified,
yes.
you cannot point your fingers on others.
Sorry,
That is how things proceed here in writ proceedings. This is not PIL.
yes, your lordship.
Anything wrong committed here and there, you come and complain. That will not do. You have to say that you are qualified.
Yes.
Hmm.
Your Lordship, may I please?
Yes, now you are coming.
Yes, Your Lordship, the tender has been already accepted and we are the selected party of the tender.
Huh?
So we are the tender, we have won the tender already. But without any reasonable ground, the superintendent engineer has cancelled the tender.
But when have we come to this court? After 4 months?
Yes, sir,
What did you do? Cancellation happened when? April 24th.
Yes, after that, after this, we were trying to pursue the department through the oral means and through some letters and all, but they
No,
didn't
no, no.
accept any. But they didn't accept, and they
There is
they
no,
didn't
there
want
is
to
not,
accept it.
there is no one single document here to show how you pursued the matter. No complaint, nothing like that. There's no document as such.
Yes.
Instead, there is one document which says that retendering was done. You participated, but again, you are not selected.
Yes, Your Lordship, but
So now can you go back to that first 24th April saying that the first tender I was selected. So let us go back to that. Can you turn back the clock?
yes, but without any reasonable ground, it has been cancelled, and after we tried to pursue, then they
That
said
is
that
why-
the tender will be there,
That is why you should have immediately come before this court.
and the tender should be held on that particular place where the project is to be. But they have called, but they have called the other party in the Nahalagan, and they have conducted the tender here, and the tender had been offered to them.
Hmm.
They have won the
No,
tender.
no, whatever the reason may be,
So these are the.
whatever the reason may be,
lacunas.
whatever the reason may be, on 24th April 2023, there is already an order saying that there should be a retender. Although you were the lowest tender recommended by the executive engineer, as he said that on re-evaluation, there appears to be some lacuna, there's some problem in the financial bid.
May I please, my lord?
Yes.
My lord, I am challenging the impugn transfer order dated 4/7/2023, my lord. My lord, I have been transferred from Lemi Pakekesan,
Page
20, my lord.
20.
Yes, my lord.
You've been transferred. SEPA.
My lord. My lord, in fact, transfer and posting are an incidence of the service, my lord. I'm not aggrieved by my transfer, my lord, but I'm aggrieved by the manner in which I've been transferred, my lord.
You're in which post? What post?
I'm
are
at
you holding?
DLRS, my lord.
Sorry?
District Land Record Officer, my lord. It's in the next page, my lord. Now, this is a UO note, my lord, issued by the MLA cum President BJP. Whereby he has issued an UO note asking that the private respondent herein, my lord, he should be posted at Lemi, my lord. And this private respondent, my lord, he is not even a DLRSO, my lord. He is a assistant survey and settlement officer, my lord. But he has asked to transfer him, my lord, in my place, my lord. Despite the fact that he being not a full-fledged DLRSO, my lord, and he has asked to take the charges, my lord. Down below, my lord, the date is 24 April 2023, my lord. On 24th of April, this UO note was issued, my lord.
This person is respondent number.
Respondent number 3, my lord. He is the MLA come state BJP president, my lord.
Sorry?
State BJP president come MLA, my lord. He is the MLA, my lord.
Who?
The private respondent number 4, my lord.
Okay. No, I'm asking about respondent number 3.
No, sorry, respondent number 3, my lord. Respondent number 4 is the assistant settlement survey and settlement officer, my lord.
Oh, 3 is the MLA. You made MLA a party.
Yes, my lord, because he's issued a UO note, my lord.
Okay. And
Now, my lord, can you see the date, my lord, down below, my lord? 24th of April 2023, my lord. The UO note was issued, my lord.
where?
Down below, my lord, the date, my lord. 24 April 2023.
It is 25th. Your type copy does not contain the date.
No, type copy, my lord, I wrongly typed it as 25th, my lord, but then in the page number 27, my lord, down below. 24 April, my lord.
Correct, 24th.
My
But
lord.
in the typed copy, you have not typed it out.
Yes, my lord, I'm extremely sorry for that, my lord. My lord, subsequent due to my lord, pursuantly, after this UO note issued, my lord, may kindly turn to page 37.
Thirty-seven.
Yes, my lord. This order was issued, my lord, by the Secretary Lane Management, whereby the private respondent number 4, my lord. May I read it, my lord?
What is his name? Serial number?
Serial number 1, my lord. Namum Hina Nakap.
Respondent number 4.
Yes, my lord. He is the ASO, my lord. Assistant Surveyor and Settlement Officer, my lord. He is not even the DLRSO, my lord. My lord, may I kindly see the date, my lord. 31st of May 2023.
31st May.
Yes, my lord. Pursuant to the UO note, my lord.
Hmm. 37.
Yes, my lord. In the remarks, my lord, they are allowed to look after the DLRSO charge of their respective district until further orders, my lord.
Who is serial number 2?
Serial number 2, my lord, I'm not concerned with him, my lord. Why this order, my lord, both of them were transferred, my lord, to their respective places, my lord.
Respondent number 4 was transferred to?
Lemi, my lord, Pakistan, where I have been, where I am serving, my lord. Well, I am the DLRSO, my lord.
Lemi.
Yes, my lord.
Transferred to Lemi.
Yes, my lord. And he has been asked to take the charge from me, my lord.
And where are you?
My lord, I was in Lemi, my lord. My lord, may kindly see when this order was issued, my lord. I was still posted at Lemi, my lord. I was discharging my duties, my lord.
Where are you now?
Now, my lord, I've been from Lemi, I've been again transferred to Sepa, my lord.
By which order? By which order?
Page 20, my lord. The two after 4 months, 2 months, my lord. After that person was transferred to Lemi, my lord. In my place, my lord. Page 20, my lord. I was serving them. I was discharging my duties, my lord.
So how could 2 persons be there discharging the same duty?
Yes, my lord. That is what I'm agree with, my lord.
No, I'm asking you. You are the petitioner. You should know.
Yes, my lord.
See, you were posted to Lemi
Yes, my lord.
by this order of 23rd February 2021.
Yes, my lord.
Correct.
I was discharging my duties out there, my lord.
Then thereafter on 4th July.
Yes, my lord.
No, before that.
Before that, yes, ma'am.
Before you were transferred out.
My lord.
The respondent number 4 has been transferred in.
Yes, my lord.
To Lemi.
Yes.
To look after the DLRSO charge.
Yes, my lord.
Then you were already there.
My lord.
Lemi.
My lord.
So how could this happen?
Now, this has been done only on the basis of the UO note initiated by the MLA and the BJP president, my lord.
Understand.
That is what I'm agree with, my lord. The manner in which
That we have understood. That we have understood.
My lord.
Question is, how can 2 persons work in the same post for 2 months?
My lord.
31st May, somebody came and joined Lemi and given the work of DLRSO. You are already there.
I'm already there, my lord.
As working as DLRSO.
My lord.
So both of you are working together.
Yes, my lord.
For 2 months.
I've been working, my lord, because I was not transferred out, my lord. But subsequently, my lord, by this impugn order, my lord, they now realized, the government realized that there is in fault, my lord.
As on today, where are you?
I'm in Lemi. I've been instructed that he has taken leave and he's on leave now.
He's on leave.
Yes.
Since when?
My lord, I have filed a representation, my lord, which I have placed at page number 38, my lord. I have not received any reply or any, that has not been disposed of, my lord. So after filing of my representation, my lord, I am on leave, my lord. That has been happened.
24/7. So what took you so long to file representation also?
My lord, therefore, my lord, the manner in which all this
No.
transfer order has been carried out, my lord.
No, thing is that on 31st May, by some order,
My lord,
somebody else was brought in to your office
my lord.
and you didn't do anything about it.
No, my lord, because I was serving there, my lord. So I was not transferred out, my lord. So the charge was with me, my lord. But the moment, my lord, they realized, my lord, they issued this impugn order, my lord, transferring me out of Pakekesang, my lord.
Correct. 4th July was just last month,
My lord.
4th July. Then you have written a representation on 24th,
Yes, my lord.
after 20 days. What has happened to your representation? You don't know.
No, my lord, it has not been disposed of till yet, my lord.
Yes, government, who's there?
I'm sorry, my lord, here the standing council land management, Mr. Kamduk was supposed to appear for all the response.
He was here.
Yes, my lord, I think.
This
he's on,
morning?
On legs in court.
He's on legs.
Maybe, I'll just check out.
Let him come, we'll see.
My lord.
Okay, we'll wait for some time.
My lord, always.
Ma'am.
Yes.
I thought so. My lord is engaged in. My lord, I am challenging this impugn order. Assessment, impugn assessment, loss assessment report and submission of the report to the DC0 on 29/3/2022 at page 45 to 47. Well, for a moment, my lord, there was a dispute between the private respondent and the petitioners over a community land. Now the private respondent have fraudulently obtained the LPC, my lord. Fraudulently obtained the LPC, and that was put to challenge by the petitioners, and the LPC was cancelled, my lord. Now, after thereto, my lord, the private respondent filed one read petition before this honorable court, and honorable court has interfered with the cancellation of the LPC, my lord. I'll come with the annexure, my lord. So then what had happened, my lord? Then thereafter, the deputy commissioner was directed, my lord, to give a hearing and to decide the legality of the LPC as cancelled, my lord. So thereafter, my lord, what had happened was the private petitioners, they filed one title suit before the senior division civil judge 0, my lord. And thereafter, there was a direction to carry out the assessment, my lord. Then the deputy commissioner did not carry it out, my lord. Then, in the meantime, my lord, what had happened? The private respondent files one application before the deputy commissioner saying that, look, the incident has occurred somewhere in 2020. And then, my lord, after 3 years, 2 years down the line, my lord, files an application for assessment of the damage of agriculture and horticulture plantations in the garden, my lord. So then what had happened? DC0 thereafter, my lord, passes an order on 28/3/2022, and my lord, and then the assessment report was prepared next day without visiting the field. So, my lord, I demonstrated the paper, my lord. Annexures. My lord will come at page. Yes, sir. My lord, kindly come to page 23, annexure 1. The first limb of argument, how this honorable court has interfered with, my lord.
Yes.
Now, my lord, will kindly come to operating portion straight at page 24, paragraph 6 and 7, my lord. On considering the submission made by the counsel for the parties and on perusing the impugn orders, this court finds that no notice was issued to the petitioner and neither was any opportunity of hearing provided to the petitioner prior to the issuance of the impugn orders cancelling the LPC. In view of there being violation of the principle of natural justice, this court holds that the impugn orders dated 1610 to 2018 issued by Director of Land Management, Government of Arunachal Pradesh, and order dated 16/5/2019 issued by the Deputy Commissioner 0 are not sustainable in law. The same are accordingly set aside. Now, my lord, paragraph 7. That the state responses are given liberty to reconsider the validity of the petitioner LPC express after giving an opportunity of hearing to the petitioner with regard to the complaint made by the respondent number 4 and 5 against the issuance of the LPC to the petitioner in the year 2008. It is needless to add that if the state respondents conduct the above exercise, the respondent number 4 and 5 should also be given an opportunity of being heard by the state respondent prior to a decision being taken on the validity of the petitioner's LPC. The entire exercise, if any, should be completed at the earliest, preferably within a period of 2 months from the date of receipt of a copy of this. My lord, then what had happened? Kindly come, my lord.
What is the requirement of having this loss assessment report?
The requirement was that there was an FIR, my lord. FIR filed against these petitioners by the private respondent.
Okay, saying?
Within a period of 2 months, then at page 26, my lord, the learned deputy commissioner passes this order, my lord. Now, 29/3/2022, my lord. My lord, these are the on the following grounds, my lord. My lord, we are reading together, my lord.
Yes.
Yeah. This office being self-participated in the process of issuing LPC to so-and-so by then Deputy Commissioner 0 will not be fair to decide on its own course, and therefore for the fairness, parties should contest before the competent civil court. Now, my lord, the Honorable High Court order is something else. The process of, my lord, process and cancellation of the LPC stands on a different footing, my lord. Here the learned Deputy Commissioner has faulted himself. This office is not, second, my lord, Roman 2. This office is not fully acquainted with the taking of evidence and other procedures, and therefore it is better to contest the case before the competent civil court, wherein this office or office bearers would be witness to the said case. Fair and full justice will be able to delivered by the competent civil court by deciding the disputed questions. Here she closes the case. Now, my lord, kindly come. Now, pursuant to that, my lord, what had happened? There is a standing order by the learned senior division civil judge 0 also, my lord. Will come at page 28, my lord, annexure 3. This application was filed. My lord, the operating portion kindly come to page 30.
30.
Page 30, my lord. In the light of above submission, Mr. So-and-so prayed this court to pass interim orders as follows. Constitute commission by directing the performer respondent to carry out the technical assessment of the properties damaged on 27/5/2019 and to submit report within 15 days. To direct the respondent, defendant to allow the applicant to plug, harvest tea leaves and kiwi in the sweetland, restraining so and so. So this is also there. Restraining. My lord, I am concerned with the first part.
Yes.
Now, this first part, and then my lord will come. This is the one of the sign coming. Now, finally, my lord, the direction is given at page 35. My lord. Para 16, my lord. In view of the above discussions, the following order is passed. A commission is hereby issued and Deputy Commissioner Lower Subansiri District is directed to constitute a board to expert carry out technical assessment of the properties damaged on 27/5/2019 in the Sweetland. The commission shall submit its report within 3 weeks from today, my lord. However, in the interest of justice, it is directed that board shall give notice to the respondent defendants and allow them to participate during the process of assessment in order not to cause prejudice to them. My lord will mark this. This is very important, my lord. B, the respondents are directed not to obstruct applicant, and here, my lord, the respondent defendants are the petitioners here, my lord, are directed not to obstruct applicant and her laborers from entering into the Sweetland so as to allow them to pluck, harvest the tea leaves in the kiwi. The respondent defendants are directed not to restrain, enter so and so forth, my lord. This order was passed, my lord. This is which order dated? My lord, this is 13/11/2019. Now, my lord, where the things have gone wrong, my lord will see this. Now, my lord, kindly come to next page 36. Now here, my lord, kindly see, my lord. 25 February 2022. The private respondent writes a letter to the Deputy Commissioner for necessary order for assessment of damages of my agri-horti garden.
Yes. With
due respect, I beg to state that I have a private land measuring 211.31 hectares. So at Peelsit, New Area, New Panya, and the Lower Subansiri. The said land is bounded by north so and so. Hillock. I have applied for LPC for the said land to this office, and after going through all formalities, this office has issued me LPC that is so and so. I have been against the Neelam party. Later on, after completion of investigation, the Bureau of Police has laid the charge sheet against some of the Neelam party white charge sheet number so and so. That the destruction of properties of my garden was so severe as 35% of my cultivations were completely damaged. Therefore, I approached this office for holding loss assessment of damaged property by submitting a letter thereby praying for constituting a loss assessment committee. That this office has issued an order number dated so and so, deputing Sri So ADC Yachuli to perform the ministerial duty day of export verification to be done by the district horticulture officer, 0 for assessing damages of my properties on so and so date, 27/5/2019. However, repeatedly Neelam Party disrupted the loss assessment attempt by the officers of district administration until date. The assessment could not have been done. That it has been more than 2 years, Malad will mark this. Repeated attempt to assess the loss is being abrupted, and by now it will be difficult to assess the same. However, after registering the FIR, registration of the FIR dated 27/5/2019, the investigation officer and others have verified the spot place of occurrence and recorded that around 500 nodes of kiwi plants, 200 apple plants, 5 numbers of level dwelling houses, a cow shed, and the entry gate of the garden is being damaged by the Neelam Party photocopy. Thus, I request you kindly to direct or pass an appropriate order to expert horticulture office to assess the loss amount basing on the record available in the charge sheet. Now, my lord, 2 things are coming up. The civil court firstly says, directs the deputy commissioner to constitute the committee, my lord, expert committee. And the deputy commissioner has not constituted. Secondly, this letter, on the basis of this letter, my lord, kindly come. Now, this was endorsed, my lord will see, this was endorsed, page 38, my lord. My lord, then he endorsed to the ADC. Now, deputy commissioner writes, ADC. My lord, there's first paragraph, page 38. It is noted by the additional deputy commissioner. An application duly addressed to DC Lower Subansiri Registry from so-and-so, wife of so-and-so, for assessment of damage to her agriculture or agri-horti garden and field seed area basing on so-and-so flexor. However, on detailed study of the application and the records attached therewith, the following facts and figures are found. As para 2 of the application, the matter appears to be arising out of the land dispute in between 2 opposing party, we so-and-so and the Neelam Party. Since a FIR been lodged by the applicant in a police station, and the police has had investigated the case and charge sheeted filed in the Honorable Court of Law, the matter appears to be sub judice. First, it says the matter is sub judice, and this officer was very conscious of the order that a 13/11/2019 passed by the Senior Division Civil Judge 0. As per para 4 of the application, an earlier occasion also the district administration had attempted to assess the damage of the assets of the applicant by the Neelam Party, but the assessment team failed to do so due to obstruction from the 3. As stated in para 2 of the page 2 of the application, the applicant quoted the investigating officer verification report of destruction of around 5,000 nodes of kiwi plant, so-and-so, along with destruction of other infrastructures. The investigation officer had also quoted the same figures in the final report of the matter, which appears to be not meticulously counted, my lord. Therefore, it appears.
Mr. Tara, one thing, this land belongs to whom?
Actually, my lord, it belongs to the Neelam Party,
Neelam
Neelam
Party.
Plan. Then.
And the private respondents is given LPC.
Correct.
LPC.
She was given LPC, my lord.
For the same land.
For the same land.
So what?
And the procedure was not followed, my lord.
Okay.
Then there was a complaint before the DC 0 and the Director Land Management, my lord. So then what had happened, the LPC was cancelled. Then again, that cancellation order, as my lord has read this Lordship Michael's order. So they interfered.
Cancellation order was challenged. Then thereafter what happened?
Thereafter, the deputy commissioner was supposed to carry out the verification. The deputy commissioner did not do the verification.
The verification for what? Loss assessment? Or
No. As to ascertain the validity of the LPC, my lord. My lord will see that Lord.
Page 35.
No, my lord, not that's 35. 35 is something. My lord, this Lordship Michael's order is there. Judgment is there. Page.
Oh, that I've seen. Thereafter, what happened?
Thereafter, my lord, nothing had happened. Nothing had moved. Then this page 29 order 35 at page 35, right?
Yes, page 35. What is this order then?
There was a title suit filed by the private respondent.
Private respondent or the petitioner here?
Petitioner here, sorry.
Petitioners.
Petitioners, yes. Then there the private
Title
respondent.
suit for that plot of land.
Yes, yes. Then
Ultimately, what is the direction?
ultimately the direction
35,
was,
page 35.
ultimately, my lord, the miscellaneous application was filed by the private respondent for in the title suit to do the loss assessment, my lord.
Okay. Then what happened to the title suit itself?
Title suit is still pending.
Still pending as on date.
It's still pending. Lord.
So the dispute regarding the land is still there as on
It's
date.
still there.
But as per this page 35, it says that the private respondent should be allowed to enter and the suit land, pluck and harvest tea leaves, kiwi and all that. And
There in the miscellaneous application, my lord, the petitioners are the defendant.
this is order is passed in the miscellaneous case.
Miscellaneous case, directing this follow
Okay, where is the beginning?
with following directions, my lord. And this was never given effect to by the deputy commissioner. Now he passes an administrative order on a different footing, my lord. So, my lord, kindly come.
So this miscase order was there
Mi-
to make an assessment.
To make an assessment, but the deputy commissioner did not carry it out.
Then on what basis is the impugn assessment made?
This assessment was made on the basis of the final form report filed by the officer in charge of the Zero Police Station. Not on the basis of the direction of this honorable, the honorable senior division.
In the miscase.
In the miscase. That's what I was demonstrating. my lord. That my lord will kindly come to this page, particularly page 36, my lord. This application was filed by the private respondent, Annexure 4. There she is praying for, my lord, kindly come to para 2. It will be very clear from here.
No, one thing, see, miscase was on a direction for making assessment also.
But that was
And here in the other side, it was not carried out.
No, not carried out by the.
And the private respondent separately filed one application to the
These
DC,
representation at page 36.
to the DC.
And
And in terms of that representation, this order was issued.
This order was.
And ultimately,
Without-
without informing the petitioners,
Petitioners.
this assessment was made.
Correct, my lord. Very
Was-
pertinently, my lord. I'll show one order, my lord. Page 44. Kindly come to page 44 for a moment, my lord.
Yes, the order of the
Annexure
DC,
6.
the order of the DC.
My lord, kindly see. This was passed on 28 March 2022. And my lord will see next page on 29, next day, my lord. Next day, page 45, Annexure 7.
Now, so on this note, we issue notice, Mr. Tara,
Yes.
and we stay the order of the assessment.
Correct, my lord.
And at the same time, we also observe that there is no bar for the authorities concerned to make an assessment in terms of the order passed in that miscase.
No problem.
So that they can figure out,
Correct.
you are there, they are there, assessment done together. And the title suit will go on,
Correct, my lord.
isn't it?
That my lord observation is correct because on at page 50 also, my lord, we have written. We
Okay,
have,
government side, anyone is there?
Yes, my lord.
Mr. Rathas?
Basically, yes, my lord. These are disputes between two private individuals. my lord.
Correct. So we are seeing, we are just considering at best what can be done
Yes,
for the
my lord.
parties.
In fact,
Apparently, it appears that assessment was made just within one day.
yes,
And in fact, the trial court had the civil court had said that you make the assessment by giving chance to the other side also. So that will not interfere on that. Let them do that if they want to. But as far as this one day assessment is concerned, let it be stayed for the time.
yes, my lord. In fact, at page 48, their own representation, a statement has been made that basing on that assessment report, already a title suit has, this money suit has been filed claiming damages of 49 crores on the basis of that.
Who has claimed? The respondent, private respondent.
Private respondent. Already,
So this never ending, huh?
yes.
Let them do the assessment fresh, but definitely in violation of principle of
Uh,
natural justice.
Page 48, my lord will see, para 1, 2, 3, third para. That on the basis of the loss assessment report dated 29/3/2022 by the DHO 0 and HDO Yachuli and
What is
after
the stage? What is the stage of the money suit?
Well, just
You are party there?
WS stage.
Now the loss assessment is made. Supposing, and then who will pay that money?
Now, that's why that another title suit has been
The
filed
money,
by
the money will come from Neelam Party.
Neelam Party, my lord.
Okay.
Then again, we will institute damage suit against the DHO, DC and the horticulture officer. Without visiting the field, how you can do this? You cannot do things in that manner, my lord. When the statute prescribes.
What is the stage of that money suit?
Well, that claim and counterclaim.
Okay.
WS. My lord will interfere with this and then let if at all that order dated 13/11/2022, if they.
Okay, please write down. I heard Mr. T.T. Tara, learned counsel for the petitioners, who submits that by filing this writ petition, the petitioners have challenged the order dated 28/3/2022 by which the Deputy Commissioner, Lower Subansari District 0 had directed the preparation of loss assessment of agriculture, horticulture, garden of the respondent number 4. Respondent number 6. On the basis of the final report of the investigating officer of 0 police station. To stop, the petitioners have also, now within bracket, you write an extra 6, huh? 0 police station, within bracket, an extra 6. To stop. The petitioners have also challenged the loss assessment report dated 29/3/2022, within bracket, an extra 7 series, by which the district horticulture officer, Lower Subansari district, has prepared the assessment, loss assessment. Pertaining to the loss sustained by the respondent number 6. Stop, next paragraph. It appears that there is certain dispute regarding the ownership of the land on which the cultivation has been done by the respondent number 6. So stop. The dispute is between the petitioners and the respondent number 6, and for which title suit number 7 of 2019 admittedly is pending before the civil court at 0.
Senior division.
Civil court within bracket senior division at 0. Stop. In the title suit, Miss case number 55 of 2019 was filed by the respondent number 6. Praying for assessment of the loss sustained by her, and the learned trial court white order dated 13/11/2019 had directed The Deputy Commissioner, Lower Subansiri District at 0, to constitute a board of experts to carry out technical assessment of the properties damaged on 27/5/2019 in the suit land, and to submit a report within 3 weeks from the date of order. To stop. It was also directed that the opposite parties oblique writ petitioners herein be issued notice so that they can participate in the process of assessment. Full stop. According to the petitioners, nothing has materialized from the order passed by the learned trial court on 13/11/2019. And on the other hand, against the final report submitted by the investigating officer 0 police station in 0 PS case number 20 of 2019, the Deputy Commissioner had directed the District Horticulture Officer Lower Subansiri District at 0 to prepare and submit a loss assessment report to stop. The deputed officer then, within a day and behind the back of the petitioners, had prepared the loss assessment report. To stop, aggrieved the petitioners are before this court. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. N. Ratan, Lanet, Additional Advocate General, accepts notice on behalf of the respondent numbers 1 to 5. 1 to 5. Stop, requisite extra copies of the writ petition be furnished to him within 2 days. Stop, petitioner to take steps for service of notice upon the respondent number 6 by registered post with AD due within 3 days. Next para, having regard to the projection made by the writ petitioners, the impugned order dated 28/3/2022 within bracket annexure 6 and the communication dated 29/3/2022 within bracket annexure 7 series are hereby stayed till the next returnable date. To stop, it is further observed herein that there will be no impediment for the respondent authorities concerned to make an assessment in terms of the order dated 13/11/2019 passed by the Learned Civil Court Senior Division in Miss Case number 55 of 2019, arising out of title suit number 7 of 2019. With the participation of all the stakeholders. List the matter again after 4 weeks. Yes, great.
Only 7.
Are we going back to 7?
Yes, yes. My lord, the understanding considers here, man.
I'm sorry, my lord, I was on leg in the corner. So,
My lord, the manner in which this impugned order has been issued, my lord. In
Mr.
fact, in my
Kamtu.
humble-
Yes, yes.
what has happened here is you have read the thing,
Yes.
you have gone through it.
Yes.
Why has it happened like that? MLA has said that he wants somebody there. Now, this person, the petitioner is a deputy district land record and survey officer.
Yes.
Correct. And the other person, in fact, is an ASSO. But since the MLA desired that he should be posted there, he was posted there. Posted there means the place was already occupied by somebody.
That is true, Lordship.
So without the place being vacated by that person, how can you post somebody there? Imagine
Now, Lordship, since.
what they will do.
Yeah. Lordship, what happened in the land management department, we are having more than 25 districts. For each district, in fact, there ought to have been DLRS, District Land Revenue and Settlement Officer. But we have limited DLRS. So in all this, in these district, there has to be one DLRS.
So that is why you have engaged this ASSO.
Yes, Lordship. That is why, Lordship, he has been given officiating promotion.
Okay, that is one aspect.
Yes.
The other aspect is that when that petitioner is rightly or wrongly already posted there from before, without transferring him out anywhere, you are posting one more person there in that office. So how can these two persons sit there together? So, but they were sitting there together, it seems, for at least for 2 months. And after 2 months, you have shifted the original person out to some other place. He has submitted one representation and he has taken leave. What to do? There is no room for him, so he has to take leave.
Now, what, Lordship, we can gather from Annexure 1 at page number 20, Lordship. This gentleman, the petitioner, now he has been posted to SEPA. SEPA is also, in fact, is coming, is also a district, and SEPA is the headquarter. And Lordship has also seen that, Lordship, the petitioner, he himself has annexed 2 documents prescribing the guideline for transfer and posting. He has already crossed 2 years in this place. From where he has been transferred to SEPA. In fact, we are also saying that
No, that comes later on. The first question which has come up is how can somebody be posted in a place when that place is not vacated by anybody? A person is already holding office there. He was sitting there since the year 2021.
Yeah, by this order, Lordship, now the petitioner, by the order.
No, that shows that the authority concerned has not acted bona fide. It also speaks about non-application of mind. If you want to put somebody A to that post, okay, whoever is there in that post, you shift him out by the same order. He will go here and this fellow will go there. Normally that's what happens, isn't it? But here is a case when somebody is already there. He's not transferred anywhere, but again, you are posting one more person there.
No, why this order, Lordship, page number 20, Lordship, 4th July. Why this transfer order, the petitioner has been transferred to SEPA, Lordship.
No, that is after 2 months. You come to page 37. On 31st May, respondent number 4 is posted to Lemi. Petitioner was sitting there in Lemi. Anyway, you think about it. We'll come back at 2 and see what can be done.
Lordship. Yes, Lordship.
Just find out what has happened.
Yes.
In the meantime, we'll come back at 2.
I can, but again, look at general and senior counsel, sir. He gives matter in report number 2. So this item number 13, 14 and 15, may kindly be listed on 12.
12th of September.
12th of September.
12th of September.
Yes.
Is it a joint prayer?
Yes.
Joint prayer?
Yes.
As prayed for by the learned counsel for the parties. Thus, this is the matter on 12th of September, 2023. for admission.
Item number 16, 17, 18, 19. On 25th September.
16 to 19.
Yes.
Similar order in the 16 to 19,
Yes.
but the date will be
25th September.
25th of September.
Great.
Yes, Mr. Kamduk.
Yes, my lord, I have seen both the orders, lordship. Page number 20 and 37 orders. Of course, lordship, there is some discrepancies in issuing this order. Page number order at page number 37 ought to have been preceded
Yes.
the order that was issued on at page number 30. I have to try to contact my secretary as to how this order could be issued. Since he is in the cabinet meeting, lordship, he could not give me the proper instruction. So may I pray that let this matter be listed on Thursday so that I can place the instruction that I will be receiving from the department.
All right. As paid for by Mr. D. Kamduk, learned government advocate, list the matter again on Thursday. Give the data to enable him to obtain instructions in the matter. After Thursday, right, for motion. No. What has happened has happened. We'll see on that day, Thursday. All right. Why? How? How are you prejudiced? No, the manner in which you have appeared this court, before this court, 4th of July order, you're coming in August, end of August. How will it matter? 2 days. Yes, next case. Yes.
I am challenging the legality and validity of the appeal and termination order related to by the respondent authority.
Where is it? Page number?
That is at page 31, 22.
31.
Yes, 31 to 32. But whereas by introducing one post and fabricated order number so and so, that is 02/11/2020, you so and so have shown yourself appointed regular SPRT without the knowledge and approval of the competent authority and serving as PRT under the DBSE Londe, Arunachal Pradesh. Whereas in the same post and fabricated regularization, it has been purported that the appointment regularization has been done in pursuance of the recommendation of the DPC held on the 28/9/2020 under the chairmanship of Srimati so and so Commissioner Education, Government of Arunachal Pradesh. Whereas the inquiry committee might not be part. Whereas the inquiry committee constituted to inquire into the fiasco after detailed analysis of the relevant record has clearly found that your name was not at all recommended by the DPC that is so and so. Further, it has also been found that this appointment order has never been issued from the file number so and so, which is under the custody of the department. Whereas SOCUS notice that is so and so was issued to you to explain within 15 days your position as your act of illegally procuring regularization, appointment, or a post of PRT is punishable offense in the eye of law. However, you have neither furnished any reply to the state SOCUS notice, nor have tendered any explanation whatsoever on the issue. Hence, it is rationally presumed, that you have nothing to say on the issue. Whereas the pay and pays and allowances of your services post which you have legally procured are inadvertently borne by the state in check of public money which cannot be allowed under any further. Now therefore, you are hereby directed not to perform function as PRT anymore under the Directorate of Elementary Education, Government of Arunachal Pradesh, Itanagar. And this order may be treated as order of termination of your service, which in fact is not required when you were never been appointed as PR. Now, my lord, two things have not been complied here. One, that purported software notice has never been served to me. Number two, the purported inquiry committee, I was not given an opportunity of being heard, And number three, I have completed 2 years of my probation period. So therefore, I have the protection under Article 311 clause 2 of the Constitution. Be that as criminal. Now, will kindly come to my status, my locus, page 17 onwards. I'll demonstrate it.
Page 17.
Yes, page 17.
What is PRT, by the way?
Primary teachers.
Primary.
Primary.
17 is your appointment order.
Yeah, I was appointed as junior teacher on contract basis under SSA law. And this has been continued. Further,
That was in 2014.
yes, I'm coming to that. I'm nowhere because of this termination order. Well, page 20 is my BA order as part 3 examination markings.
No, where's the appointment order?
So I'm coming to that once I close this, or should I take my lord to the appointment orders?
You straight away to the appointment order. It does not say you are not qualified. It says that you were never appointed.
Never.
That is why.
Page 20.
23.
22. On the 2nd November. On the base, that scheme that is written, my name is here, and my appointment was made against, I'm Chuku Taja, my appointment was done against Sonaram, PRT retired, under the disposal of BDSC Anjar. Now, we'll see. Next paragraph. The appointment shall be on probation for a period of 2 years with effect from 01/11/2020. His her continuation beyond probation period for 2 years shall be subject to satisfactory performance during probation period. Now the law is well settled. When a person is holding a civil post, whether legally or illegally, you must comply with the process provided under Article 3 and clause 2 of the Constitution. And in a similarly situated case, my lord have already dealt with, and I am relying that judgment. Now, my lord, this is the one, and I have joined at page 24, the real rule. 5 copies here at page 45, 19 November I have joined. Then, after joining the DDSC of Changna, Hawaii, I was again posted to DDSC London by order dated 25 October 2022. Then forwarding of my last pay certificate, LPC and service book by order dated 25 and page 27.
Now, what is this release order? You have been posted elsewhere.
Yeah, from Anjar to then I was transferred to London.
Okay.
Another district. And this is my last pay certificate. This is my pay certificate 25/10/2022. With PRT. Then I was transferred to Chapsa Primary School, where I have joined on 7 December 2022 at page 29. 5 copies at page 30, your lord. And
No, Mr. Tara, how did this all come into, how did it all come into the picture regarding you not having been recommended by the DPC at the relevant time? And inquiry had to be done. Was there any complaint as such or anything in-house inquiry?
But I am not aware of that. What I am concerned is, my lord, will kindly see that I have given a representation to the Director Elementary on 6/2/2020 page 22 for my regularization. This is my application, Your Honor. Because I was already serving SSA teacher.
What is the date?
Date is 6 February 2030, page 22.
But where's the date? Okay, on top.
Top, on the
6
top.
February, okay.
Correct. So pursuant there to this appointment order came in, appointing me as a PRT.
You were appointed as a junior teacher.
Yes.
On contract basis under the SSA program on a fixed pay
Correct.
in the year 2014.
Correct.
Then after serving many years, he was paid for regularization.
Yes.
Now it so happened that by this order of 2nd November 2020,
Correct.
against the vacancy of so-and-so, retired vacancy,
Correct.
you have been appointed. And it says that on the basis of recommendation of the DPC.
DPC.
But then again, the impugn order says that there was never, your name was never there in the DPC recommendation.
There was also a inquiry.
Hmm.
I am not concerned at the moment, Lord. You know, even this, the purported so-called notice and termination order were never served to me. It was made viral in the social media, my lord. I have made a categorical statement on that. My lord, will kindly come to para 30, page 9.
Yeah, all right, Mr. Tara, all those aspects we'll examine in due course. All right, at this stage, we'll issue notice.
Look, kindly see this minus order is there. In one of the matter which might have been dealt of the similar fact to that. There is a violation of principle of natural justice on 2 counts, my lord. One, the so-called notice has never been served to me, nor the termination order has been served. And according to that improved termination order, there was an inquiry. The inquiry, if there was at all an inquiry committee, my lord, I am ought to have been asked to defend.
See, Mr. Tara, that is what you're saying. That is what you're saying. There was no show cause notice given to me, no hearing was given. There was no such inquiry to my knowledge. That is your thing. But this impugn order otherwise says that. So we'll examine. All right, we'll not take a call at now, as of now.
My lord, should kindly appreciate.
Hmm.
The third leave, which I have submitted.
Yes, 311.
I have completed my
Or probationary period.
Yes, therefore.
But then again, even if you complete that, and if supposing your initial appointment itself was illegal, then
in this case, my lord,
then the question of you completing and not being cannot be terminated will not arise.
subject matter of investigation.
Right, so
my lord, can we come to para 8 of the judgment rendered by lordship? In fact, that.
no, was this at the motion stage?
No, no.
Then that is why your case today is at the motion stage. So I'm saying we'll issue notice, we'll examine this, taking your points of argument. Let them respond to that. And let us see what they say. Let them also bring the records. I'll direct them to bring the records. How do you say that the inquiry was done? How do you say notice was issued to you? If there's nothing there, then perhaps that it may call for some sort of an order.
Lord,
All right.
let my brother bring the instruction on Friday. Because I know their Lord, because I have I was serving as a junior teacher. And
I know.
I resigned, you know.
See, Mr. Tara, it's not that you have come the next day. You see, this order was passed in 20th of June, July, and we're in August now.
No, you know, I was not aware of this. Kindly see. Kindly
No,
see.
you're not aware of what?
I was not served with the termination copy also, my lord.
How did you come to know this termination order?
Social media.
When?
Paragraph 13, my lord, kindly come.
When?
Paragraph 13 at page 9. Ten seven. It was made viral into the social media. And this is a stigmatic termination, you know. Kindly appreciate that count.
10-7, but 10-7 also is of course.
My lord, kindly see, I am out of service, my lord. A person is relegated to his feet.
See,
At least, my lord,
see, if you have a case and if your writ petition is allowed, you'll get back whatever you have to get back.
my lord,
Correct.
can-
So without examining this now, order has been passed rightly or wrongly.
Correct.
To join that order again now and say that let continue as if nothing happened, we will examine, that may not be the,
I vote on. my lord.
that may not be the best thing at this stage. And I don't intend to keep this matter for a long time. The respondents will come with appropriate instructions, file affidavit. If not, they will bring the records so that the matter can be at the earliest looked into. You have made specific allegations and they have made specific categorical statement in their order of termination. You're not even entitled to termination order because you were never appointed authorizedly. But still we are giving you this termination order. And yet again, you say that it's also social media. I was never physically given a copy of that order. It just came in the social media. That's your, again, categorical statement. So the accusation, I think it's pretty serious. It's pretty serious.
Because, apparently.
It does not happen like that actually, no?
On discourse in realm of academic arena, per se, even on the record itself, you know, the procedure which they have adopted in terminating me is a questionable. Right?
Correct.
You know,
No, see, we're accepting your argument, okay, for the moment. But unless we get some response from the other side, to make a conclusion at this stage may not be possible.
No, my lord, I go down to my lord's view. Well, can it be possible for Friday
I don't know, Friday what will happen.
or my lord Thursday? Let them come with the instruction. Because you know, a person cannot be brought in this line.
Yes, you are there for the state education.
My lord, we are for education, my lord. Your lordship is clearly pointed out, my lord, ground has been clearly brought out in the termination letter, my lord.
I don't think you have instructions now, isn't it?
No, my lord.
That's why.
So the thing is that, is it possible for you to get instructions by Friday?
Okay, my lord. We'll bring written instruction then.
See, the allegation is such
Okay, my lord.
that he claims that he have been working since 2014. When I look for regularization, now they give me this appointment order
My lord.
and it says that it is as per the screening done by the DPC. But here's a case, you have issued the termination order saying
My
that
lord.
your name doesn't figure anywhere. You were given show cause notice, you have not responded to it. So we terminate you. So let us have some clarity in what has happened, what has transpired.
My lord.
So my lord has already seen from our side, because whether the appointment itself is void ab initio. At the same time, it is the duty of the department to detect this. And after 2 years, you come out and you suddenly force me out from the job. Something, and that is what my lord has beautifully described in paragraph 9 of this Ramit Kalita judgment. And in one of the matters, in the Public Service Commission case also, there was interference by my lord.
All right, Friday.
Friday, in up to item.
Please write down. Mr. T.T. Tara, Learned Counsel for the petitioner submits that the petitioner is aggrieved with the order dated 26/2023, by which he has been terminated from service. He has been terminated from the post of primary school teacher. Full stop. He submits that according to the impugn order, an inquiry was constituted to look into the matter as to whether the name of the petitioner was recommended by the DPC at the relevant time. Full stop. The rest you cut, not required. The Learned Counsel submits that the does not serve as a copy of the termination order, and it was only through social media that the petitioner came to learn about the same. Stop. Next para. List the matter again on Friday. Mr. T. Jamal, Learned Standing Counsel Education Department, to obtain instructions. Item 9 to 12. They are all primary school teachers. Okay. Similar order in 9 to 12. Huh?
That is one aspect of
Just a minute. They're working as what?
extension officer, rural engineering.
Rural engineering.
Rural engineering in the rural development department. But I'm just trying to give just
How many petitioners?
15 petitioners. Just trying to give a brief background. I'll take your lordships with the various papers.
Then what?
I'm sorry, 16 petitioners.
16 petitioners. They are extension officers. Okay. Now, what is the next promotional post is?
Promotional post, assistant project officer technical.
there are various posts, assistant, basic post is assistant project officer, technical, assistant project officer, rural engineering. Because there are nomenclatures are different, but the post is assistant project officer.
So they are claiming promotion to the next post, promotion post.
Yes, they are stagnating since their initial appointment.
Okay.
There, I'll just give the dates.
Any recruitment rules?
No recruitment.
Then how will you be promoted?
Sorry.
How will you be promoted?
That is what the crux of the issue. I have one of my prayer in the repetition is that to pay.
But then how do you say the next promotional post is APO?
There is the next higher pay.
Next higher pay.
Next higher pay.
So on that basis, you are presuming that this is the next higher promotional post.
Because the person.
APO technical will be under the RD only.
RD only.
RD.
There is another crux.
Hmm.
There is a DRDA. DRDA is also a scheme of the central government.
Yes.
DRDA in the scheme,
Hmm.
they have issued an OM, wherein they have provided in the OM that the post of assistant project officer in the DRDA scheme
Hmm.
will be filled up from this extension officer RD.
In the DRDA.
That assistant project officer in the DRDA, the pay scale given is equivalent to the assistant APO technical.
Hmm.
Same pay scale. So in the meantime, what they have done, Milord,
That is in the DRDA.
fine,
You are in the RD.
yes, Milord,
Hmm.
fine. What they have done, Milord, this is the next phase. What they have done, when the situation came to fill up the post of assistant project officer in DRDA,
Hmm.
they took officers from RD department
Hmm.
on pick and choose basis.
Hmm.
Persons junior to us, they were picked up, appointed as APO in the higher pay scale.
Hmm.
No doubt, it's under DRDA. That is a different thing altogether. So in two counts, we are deprived. First, we could not be given promotion to APO because there is no recruitment rule. We are stagnating since then. Number two, when the Milord appointments are made on deputation to DRDA, because from RD to DRDA, they take on deputation. When the appointments are, Milord, when the persons are taken on deputation, I will not say appointment, it will not be an appointment, Milord. When the persons are taken from RD to DRDA to the post of APO on deputation, Milord, the persons junior to us, they will pick up the OM.
Okay, but do they come back?
Sorry.
Do they come back from DRDA or they remain there only?
No, they remain there. Sir. Now, another interesting aspect, the DRDA has been sought to be merged with RD.
Hmm.
Doctor will kindly appreciate.
So now there's still a march over you because they're already promoted in higher posts.
So the situation is going more worse.
So what have you been doing all these days then?
Sorry, Milord.
What have you been doing?
No.
After your juniors had gone to DRDA, we can choose rule, draft RR. Number one. Number two, is there any vacancy in APO technical?
Which the person will travel to that post. Mainly because there is no vacancy, they cannot take a stand that will not have the recruitment rule, Milord. So that is precisely my case. If I take your lordships, Milord, there are
You have been working as APO's extension officer since when?
the petitioner number 1, 3 are working at Milord, extension officer from 96, 97, 98.
Okay.
Petitioner number 4 to 9, 2003.
So what is your calculation? After completing how many years of service as extension officer, can you be considered to be promoted to APO?
That is the entire idea.
That's what. There's nothing
There is
laid down.
They are sitting tight with the matter, my lord. We did not know that our promotional avenues were not there. We joined, we were working, my lord. When the situation came, when people were going to DRDA, person here to us are shifted to DRDA, they are getting higher pay scale.
Okay,
When we got the information, that they are sought to be.
see, these things happen, you see, it is not very peculiar. These things happen. Somebody go out to some department, get promotion there, come back and sit over you because he's already been promoted earlier. Although in the original parent department, you are senior.
Yes.
This happens actually.
This
Now,
happens.
the thing is that on what basis are you claiming that you should be promoted to APO?
Can you come to my prayer, my lord? First question. Page 23, then I'll take your lordship to the various people. Prayer number 1, page 23, issue read in the nature of mandamel directing the respondents to pay services providing for revenue of promotion to the post of APO technical APO RE, assistant director RE, assistant technical assistant RE from the feeder post of APO. This below they have said in their affidavit that the recruitment rule is at the process. They have said.
Affidavit filed on when?
uh,
Your writ petition is filed in the year 2022.
They have filed the affidavit. Why not just check the date?
Is under process, they say.
Yes, 10th July 2023.
Okay. Filing date here is 12th July.
Yes,
So anyway, in the beginning of July, they say it's under process.
yes.
And it's a very short affidavit.
It's a short affidavit, you know,
1, 2, and 3.
1, 2, and 3.
Who are they? 1, 2, and 3.
I'll just say.
They are the
Are
Commissioner RD, Secretary RD, Director RD. So if recruitment rules is framed, your problem is solved?
That is one aspect of the matter. Next is that, you know, my next prayer, you know, after framing of the recruitment rule, direct the respondents to consider the case of the petitioner to next higher post. That is consequential, you know, because since we are in the, our seniority position is higher, so we are entitled for that. Now, the third prayer is that the issue written members directing the respondent to prepare updated seniority list before making any promotion to the post of so and so, so and so, so and so. And my interim prayer was, which will be my main prayer now, you know, after 3, to direct the respondents not to absorb any EO RE in the higher post of APO technical in the rural development department upon its merger to the from DRDA upon its merger with the rural development department.
When is the merger supposed to
You
happen?
know, they, so far as merger is concerned, we.
Where is the, by which document has there been an indication that they will merge?
That from 1/4/2022, the DRDA is winding up and merge with RD.
22 has happened. Now what, have they merged?
They say it is in process in their affidavit. Lordship will kindly turn. Para 14 of the affidavit, they say the merging of DRDA employees with rural development department is under consideration of the government. And very vaguely they say, in case of absorption of DRDA employees in RD department, their seniority will be fixed as per the laid down norms and procedure. What norms and procedure? They are absolutely silent. How they are going to fix the seniority? Because they are already getting a higher pay. They are already APO. We are still to get the APO. We are senior. They are our junior. You know, fine, you have given persons who are in the same seniority position, in the seniority list. But while coming to the case of regular promotion, you cannot flout the norms. I'll take your lordship.
So what can be done today? We cannot simply close the matter also. Mr. Picha, what is the status?
Status, my lord, regarding my lord, because I find this writ petition is on presumption. my lord.
No. Before you say anything, I'm asking you. This extension
Yes, my lord.
officers, in fact, they say that they've been working for a long time,
My lord.
fairly long time,
My lord.
without any promotion.
My lord.
Now, according to them, next promotional post as per the pay scale or as per the trend followed in the DRDA
Yes.
is the post of APO technical
No, my lord. The next promotion post.
as per the promotion
My lord.
petitioners.
My lord.
Okay.
Yes.
So now they say that we have been sitting here stagnating for a long time and others on pick and choose, they have been going to DRDA in the higher post. We are here remaining in one post. We need to be promoted.
My lord.
Then now in your affidavit, you say that, yes, we are making the recruitment rules.
Yes.
Very soon it will be published.
My lord. Yes.
How soon is that? When is it going to happen?
That is.
You have filed this affidavit, I think, just not very long time back, but at the same time,
Yes.
you have stated that in your affidavit. Now, without any recruitment rules, they cannot simply be promoted like that.
Yes.
We don't know what is the vacancy position.
Nine posts is there only.
Nine.
Extent is 9.
Huh?
Of APO take, my lord.
If you take 9 posts, is there.
Yes, yes.
And who's occupying that post? It's vacant.
They are all seniors. my lord.
Huh?
No, it is not vacant, my lord. They are
There's no vacancy.
No. They are
So
being-
where will you be adjusted then?
Yes, ma'am.
If the 9 posts is already occupied by your seniors?
Their affidavit doesn't say anything, my lord. Absolutely silent on this aspect of the matter. my lord. Absolutely silent.
I'll tell you why, the reason I'm asking you all these questions is that recruitment rules need not be framed straight away and considered. Even if there's a draft recruitment rules, on that basis, subject to there being vacancy, you can be considered. So that's why. What is the actual position as on date?
As on date, my lord, there is only 9 vacancy, my lord. In their writ petition in para 4, they have also stated, my lord, we have admitted to the fact. my lord.
Okay, vacancy, as far as vacancy is concerned, that is a position.
Yes, my lord.
But what about the recruitment rules? You're saying that it will be published any moment now.
No, it is under
And
process, my lord.
no, see, that is the statement here. It's very vague.
My lord.
We don't know. It's under process means it could have been under process 5-6 years back,
My lord.
still under process.
My lord.
We're still cooking it.
My
It's not ready.
My lord.
But how long will that go on? And here the petitioners are also not getting younger. They're getting older day by day. One
Yes.
fine day, it may happen, it's becoming infructuous
My lord.
because they're already crossed their superannuation age.
My lord.
That shouldn't happen.
My lord.
So we would like to know the steps taken by you.
My lord. I will take instruction. from that.
You get your up-to-date instructions and get back to the court.
My lord.
So one thing, I just, one thing,
Hmm.
one thing is very clear. here. You are bound to have the RR in place. The government, bound to have the RR, whether vacancy is there, whether there is a single cadre post, absolutely irrelevant.
Okay, then let me ask you one question. How did you enter as extension officer in the first place? On what RR? On what basis?
Extension officer RR is there. my lord.
RR is there.
Yes, ma'am.
Show me that.
That is not there in the records, you know, I have the copy.
Framed by the government or Arunachal Pradesh.
Yes, ma'am.
Only for post of extension officer.
Yes.
I'll just give you. I'll just-
Have you enclosed your appointment order in this writ petition?
No, my lord, they have not annexed.
Appointment orders are not enclosed, but
Why?
no dispute with regard to the.
No, forget about dispute, no dispute. At least you should have enclosed one appointment order. We don't require all the 16 petitioners to file their,
Enclose the seniority list, we got very, our date of initial appointments are given, my lord.
no, that is not the only thing, you see. Appointment orders contain many other things, not your seniority and all that.
No.
We would like to know on what basis you were appointed.
It is absolutely correct.
So-
but there is no dispute with regard to the fact that I am a direct recruit, my lord. There is no dispute.
No, this is for your benefit, then I'm asking the questions. Because it's not that we're doubting your appointment. Very well.
Section, yes, my lord.
Very well, you are getting appointed, but we want to know if there was some material there to show that this is the process undertaken. So we'd like to ask the respondents, what stops them from What stops them from going further to consider the promotional avenues of these appointees way back in 1996? Have they been appointed for all time to come as extension officer? So this is the thing. So that is why you see the facts, figures, all these aspects should be laid down before the court in open so that we can appreciate.
I'll assist you, Lord.
Now, this recruitment rules which you have, no, what is this?
This is for extension officer only,
309 rules.
309. One similar rule with APO would have, Milord, saved these petitioners, Milord.
No, it doesn't stop there. Had there been APO, then he would say that there should have been a post of joint director, deputy director, director, etc., etc.
It's a, Milord, it's a duty of the state. Milord, the Supreme Court has said, Milord, at least you cannot keep person without any promotional avenue.
Another aspect, I don't know whether Mr. V. Picha is dealing with that aspect or not. If there is stagnation,
It's going to degenerate.
if there is stagnation, there is another remedy to compensate that stagnation. What is that?
MSCP.
Have you given them?
Well, that I have to take instruction.
See, you know, everything I ask you say I have to take instructions. Why did you file such kind of affidavit in the first place? You examine the pros and cons and file affidavit, because otherwise you see, sometimes it so happens that parawise comments are prepared at some level
Yes.
who are not even aware about what are the factual aspects.
Well, yes.
They just do some noting here and there and just put it up.
Well,
And the person sitting there without looking, he'll sign
well,
and supply to you.
yes. Well.
And if you, without looking at it, if you file it before the court straight away like that, as it is, then you will face all these kind of questions.
Yes. Well.
That's why the council sitting in the right hand side. The task is really difficult.
Well,
It's
in
always
fact,
difficult for the right hand side.
it was difficult for the left hand side also, my lord, because this motion notice was issued by your lordship, my lord.
Right and left will keep on arguing. What about the person sitting in middle?
Well,
The person sitting in the middle has to break his head
my lord. Well, in
to
fact,
pass an order.
in the motion stage, your lordship was not issuing a notice, my lord. On the first day, my lord. But somehow, my lord, your lordship has issued notice, my lord.
So with this, you just get your instructions then.
My lord.
And in the next court date, perhaps you produce your appointment order and any other material which you have. Please write down grievances expressed by the 16 writ petitioners is that they have been working for a fairly long time as extension officer, rural engineering under the Rural Development Department, Government of Arunachal Pradesh. Full stop. They were selected with due process under the existing, what is the year? 96?
Different years.
No. The rules is 96. It's all started in 96.
If you are appointed, yes, my lord.
Under the extension officer, open bracket, rural engineering, close bracket, separate bracket, non-ministerial, close bracket. Keeping in mind the pay scale is the, what is APO full form?
Project officer.
Assistant Project Officer within bracket technical.
Milord, possible kindly report assistant project officer because there are different categories. Technical, RE, Milord.
APO-RE comes to my lord in DRDM. APO take comes under RD department.
APO.
APO take comes under the RD department. APO-RE comes under DRDM, my lord.
APO RE lordship is there. It's APO RE.
Is that the other way? RE is under the DRDA.
Yes, madam.
Our promotional post is APO
Tech.
RE. No.
No,
In the
APO
cadet-
Tech. Yes,
in the
because you are from RD department, so you would be otherwise.
Since I am
reported
in
to
the
ISO.
RD department, my promotion next higher post is APO.
Tech. APO technical knowledge.
Is under consideration and shall be notified soon. To stop further, it is also stated against paragraph number 14 of the affidavit that the state respond It says AD card in respect of respondent numbers 13, 14, 15 are returned.
My lord, 15
How
is
can they
al-
file a affidavit without appearing before?
15 is already filed, my lord.
Huh? Oh, 15 is filed.
Yes, my lord.
Number 4 to 14.
4 to 14.
Yes. Earlier I appeared 12 and 13, 14 also I am appearing.
Okay. Have you filed the affidavit?
My lord, I will be filing.
When will you file?
My lord, within 2 weeks will file.
15 has filed already.
15 is already filed, my lord.
So notice is complete then. You see, we are paying from 4 to 14. We'll give them 2 weeks time.
My lord, actually, they are delaying practice because of this is time bound by the period of that as a Jila Parishad member, 5 years tenures. Now already 2 years is gone.
No.
3 years is gone, my lord.
Delaying practice means this writ petition was moved in the month of May this year
Yes, my lord.
only.
My lord, that matter may be fixed for the administrative hearing. Meanwhile, maybe filing for the epidemics. For the earlier dispose of the matter and the justice for.
Yes, Ms. Basari, have you received instructions?
No, your lordship, we have received extra copies on 14/7 only, your lordship. 14/7, so we have communicated and we have not received yet, your lordship instruction.
Then have you communicated?
Yes, we have communicated, your
Okay.
lordship.
So how much time? 2 weeks will be sufficient?
3 weeks, your lordship.
Mr. Tagum?
3 weeks, my lord.
My lord, 2 weeks maybe give because of that. This already delay, my lord. This is the Anti-Defection Act under the Arunachal Pradesh local authorities. Prohibition Defection Act 2000.
If you give 2 weeks, again, they'll come and take some more time.
3 weeks may be granted, your lordship.
All right. Miss Arbasa,
Lordship.
no, Mr. Your
PV, my lord. PV.
P. Bui. Mr. P. Bui appears for the petitioners. While Ms. Arbasa, learned government advocate, appears for respondent numbers 1 to 4 and prays for 3 weeks time.
1 to 3, your lordship.
1 to 3 and prays for 3 weeks time to file counter affidavit. Stop. Similarly, Mr. T. Tagum, learned counsel, submits that he will be appearing for respondent numbers 4 to 14 and may be given 3 weeks time to file counter affidavit. To stop. It is further seen that the respondent number 15 has already filed counter affidavit on 31/7/2023. Next para, considering the prayer made, 3 weeks time is granted to the respondents for filing counter affidavit.
Unless.
No pleasure.
List again after 3 weeks.
Like this, your lordship.
Hmm.
Lordship, I'm appearing for number 1 to 3.
Hmm.
I beg to pray for granting of some time for filing.
How much time?
3 weeks.
Okay, what about 4?
We have taken this private.
Okay. As paid for by the learned government advocate, 3 weeks time is granted for filing counter affidavit. Await, full stop, await service report from respondent number 4. List the matter again after 3 weeks.
Government is to file their counter affidavit.
Yes.
And so far respondent number 4 is concerned, step has taken.
Okay.
Already taken. So Malad, in the meantime, I have not received any affidavit in opposition, so.
Which is the department?
Malad, Education Department.
Education, Mr. Jama was here. We'll grant them some more time.
Malad.
Please write, Mr. C. Modi, learned counsel, appears for the petitioner. To stop, office note dated 19/8/2023 indicates that AD card has come back from respondent number 4. To stop, as such, comma, notice is declared to be complete on respondent number 4. To stop, as paid for by the learned government advocate. No, as paid, you cancel that. List the matter again after 3 weeks. In the meantime, the respondents to file their counter affidavit.
My lord, in the meantime, interim order earlier.
Interim order passed earlier to continue till the next date.
Your Lordship, here I've received instructions. I need some time to file affidavit here, Lordship.
How much time?
Lordship, 2 weeks, Your Lordship. I've received the instruction.
Okay, Ms. R. Basar, Learned Government Advocate, submits that she has received the instructions and she may be granted 2 weeks' time to file counter affidavit. To stop in view of above, matter stands adjourned for 2 weeks.
Lordship, I have a little prayer because status quo is very necessary in present case. Because the private respondent number 4 to 8, before filing this writ petition and after filing also their activities is going on, carrying on without stopping. The basic the petitioner agree was that I have filed the education petition on basis of the KEVA decision. KEVA has decided between the both parties that land has to be distributed. And accordingly, they have not followed the KEVA decision. And after lapse 30 days, the private respondent, they never filed an appeal against the KEVA decision. Then I compelled to file the education petition before the competent authority. But the competent authority, without following the procedure, my education petition has been dismissed, rejected.
Okay, stop. Await service report from respondent number 4. Next para. Issue notice on the interim prayer made by the petitioner, returnable by 2 weeks. To stop. The same shall be considered on the next returnable date.
Okay, all right.
My lordship, service against the private respondent lordship, complete lordship.
Served through CJM.
Lordship.
Notice is served through the
Yes,
chief,
Lord.
chief
Yes, Lord.
judicial magistrate.
Yes, lordship. Service completed lordship.
Why through the CJM?
Lordship, in usual course lordship, it is through the court lordship.
Okay, okay.
Your Lordship, I'm filing wakalat number on behalf of respondent number 3.
And 4? Only 3.
Yes, only 3.
Parties are represented by the respective councils except for respondent number 3 and 4. Stop. Office note dated 27/7/2023 indicates that notice sent to respondent number 3 and 4 through usual service has returned back after the same is served. Full stop. At this stage, Miss, your name?
B Mema.
P.
B Mema.
B. Rema.
Yes.
B. Rema. Learned Counsel submits that she has instructions to appear on behalf of respondent number 3 and that she'll be filing her power when?
After 3 weeks.
Power to file power 3 weeks.
Today. Your Honor, today. Yes.
Filing her power during the course of the day. She further submits that she may be given 3 weeks' time to file counter affidavit. So similar prayers made by Ms. R. Basar, Learned Government Advocate, appearing for the respondent numbers 1 and 2. Prayers allowed.
Lordship, interim may be continued.
List the matter again after 3 weeks. To stop, let service report be awaited from respondent. List the matter again after 3 weeks. In the meantime, the interim order passed earlier to continue.
Much obliged.
May I, Lordship, the standing council is not in.
Standing counsel.
Mr. K. Tama.
K. Tama.
Yeah.
Counsel for what?
Conducting council, sorry, Your Lordship.
Sorry?
Conducting council. In item number 31, we are the respondent, and in item number 32, we are petitioner. So matter may be fixed after 2 weeks, Your Lordship. And we have taken the consent from the other party.
K. Tama, is it?
Yes, Your Lordship.
The conducting counsel for the petitioner, Mr. K. Tama, The conducting counsel for the petitioner in WPC number 481 of 2015. Mr. K. Tama is reported to have some personal difficulties and is out of station. Stop on a mention made on his behalf and not objected to by the other side. The matter stands adjourned for 2 weeks. You want a date?
No specific date, Your Lordship. Oblige, Your Lordship.
My lord, I beg to mention, my lord, this matter, my lord, 3435, my lord, learned senior counsel Dilip Mujumdar sir, he's appearing this case, my lord, earlier occasion, my lord.
Where, in which case? For the petitioner?
Yes. Now, my lord,
He was here today.
he's in court number 2, my lord. So as per convenient, my lord, may I pray, my lord, this matter may be fixed on 12th September, my lord.
Lordship, I have mentioned this matter already, Lordship, because of the status quo, Lordship, office building which is under construction has stopped, Lordship. And the materials are, Lordship, all rusting, Lordship.
My lord, regarding this, my lord, the earlier occasion, they come up for modification, my lord. That
Yes, that's true,
after
Lordship.
exhaustive hearing on merit, their prayer was dismissed, my lord.
Only on IA for modification of.
That is why we are.
But Lordship, here also it has reflected that reflected in the IA while disposing the IA, Lordship, on 24/1/2023, Lordship. So that's why hearing may be taken up for
But,
disposal of the.
that is fine.
this work, Lordship.
But you have not filed affidavit, isn't it?
Lordship, I have filed already.
In which case? Contempt or in the writ petition?
Lordship, both, in both, Lordship.
No, but in the writ petition, I find only affidavit of respondent number 5.
Lordship, I have filed.
File has no 5. Okay.
Director, Energy Development.
Yes, Lordship.
What about the others?
Other has not filed.
Others have not filed, not required award.
Not
Required, Lordship.
From my side, our affidavit is not required also.
Lordship. The others are not required, Lordship, because RWD is
My lord,
also
RWD
government party, Lordship, here.
RWD, their affidavit may be required, my lord,
No,
because
Lordship, they-
originally the
Government party here, Lordship.
land,
The affected party here, Lordship, from the beginning, Lordship.
But-
Because the construction is stopped now, Lordship.
I'm sorry, my lord. I was instructed by Mr. D. Mozumdar that the matter may be fixed on 12th of September, since he's coming up for one another matter also.
The other side is objecting. They say that they're enjoying status quo,
Yes,
interim
Lordship.
order, so.
Yes,
they're-
Lordship.
Yes, but. Okay, this is, can be done with last chance, my lord.
Last chance. What is the interim order? Let's see.
Lordship, interim order. Lordship
to
is-
maintain the status quo.
Status quo.
Respect of land in
limited.
question.
All right, let us give them a chance with an observation.
Hmm.
And I'll record your submission that affidavit not required from other side, other parties.
Yes, Lordship, it's not required, Lordship. I am the main party here, Lordship.
Mr. D. Mojumdar, learned counsel, learned senior counsel, is for the petitioner is reported to have some, is reported to be on legs on the other side. Is reported to be on
He's leaving tonight.
legs in the other courtroom. Stop. Since the matter is to take since the matter would take some time, a prayer has been made on his behalf by Mr. Your name?
P. Bora.
P. Bora. That the matter may be taken up, will be listed again on 11th of September. 12th of September. To stop, the prayer is objected to by Miss G. Learned Additional Senior Government Advocate, stating that there is an interim order passed by this court to maintain status quo, and for which reason
Construction of the office building, Lordship.
construction of the office building has been stalled. Full stop, she submits that there is urgency in the matter. Full stop, she further submits that the affidavit of respondent number 5 will cover the case of the other respondents, and the other respondents will not be filing their counter affidavit. Next para, considering the above submission, let the matter be listed again on the 12th of September 2023 for hearing. To stop, it is made clear that no further adjournment will be granted.
Obliged.
Interim order passed early to continue till then.